Okay, so we should be back live again in this StreamYard. So hopefully this is going to work better. I'm sorry about that. I don't know what happened with Ecamm. Obviously, something happened with the sound. I will try and fix it. I did test it earlier and it worked earlier. But welcome back to the live stream. And yes, I'm just waiting for Al to join us. But we're going to talk about the fallout of this interview and what we all think about that. And I think Al's just joined us here. He'll probably be able to see me now. Here we go. There we go again. Right, back to StreamYard. I'm trying to improve things, guys. I did test this earlier and it worked, but for some reason now it deafened you all with echoes. So let me get the new chat box out here, close down the old one. Just going to close down this old one here. Okay, so let's make this private so it should end the previous one. Okay, right. So you were saying, Al, we were talking about the response to this interview, and by all accounts, a bit of a PR disaster by my account. What do you think?
Yeah, I have to agree. I mean, like I say, from a legal perspective, no way, Depp is not going to seek an injunction on this to stop them, and that's for two reasons. First, legally, it's quite high risk. Like I said, Brown Rudnick, that's Depp's legal firm. The one thing that they've really demonstrated is the art of knowing when to stop, which is a top lawyer skill. When have you done enough? And once you've got there, don't try to fix it. You know, it's the old like Royal Engineers thing. You know, if it ain't broke, fix it until it is. But this is the danger. They are going to leave well alone, both for legal and practical reasons, because it does seem that Amber Heard is just digging herself in even deeper. So I can understand why they're sitting back. You know, never interrupt your enemy when they're making a mistake. So yeah, I mean, this is always the problem, you see, because afterwards people are generally, by definition, in any litigation, at least one party is unhappy with the result. Quite often, both parties are. But what you do then is you go and you say, well, we respect the decision of the jury. However, my client feels aggrieved, etc., etc. And sometimes say, we may be appealing this, but you take it on the chin. You take it on the chin. And what I found very distasteful is attacking juries and attacking the judge. And this ties into a broader perspective. I've literally just been reading an article on Legal Cheek about lawsuits not to be put off by anti-lawyer rhetoric. Now, I know there's no real comparison with what's happening with Rwanda and what's happening in the Depp and Heard thing, but it's the same thing. Lawyers are being attacked for doing their jobs, and courts are being attacked for doing their jobs. But we have a system, we have a rule of laws, and we accept they are not perfect. It's the best solution we can come up with at the moment for resolving disputes. And people said, "Oh, it's distasteful," attacking witnesses and re-victimizing people. Unfortunately, that's what happens if there is a dispute between people, especially as to fact. The only way to test that is to put in there and let each side have their say and put forward what evidence they want, but then have the other side have their say and challenge that evidence. And at the end of the day, somebody will make a decision as to who was the most persuasive. And that doesn't necessarily mean we don't expect judges or juries to reach the correct decision. We expect them to reach a reasonable decision based on what's in front of them. And different people can reasonably come to different conclusions. But I do think all this trying to relitigate through the media, it's very much backfiring. And I can understand why Brown Rudnick are just sitting back, and I think they have handled this very well. They kept their heads down. They didn't do a victory lap. I mean, it's always tempting to stand on the steps of the court and go, "Yeah, this is a great triumph, for victory, and we've overturned the miscarriage of justice that was the UK trial." That's one thing they could have done, but they were very dignified. They thanked everybody. I mean, it's obviously easier to be magnanimous when you have won. But all this going around just trying to relitigate the media, it's backfired. And we notice Elaine suddenly vanished, and there's lots of rumours and speculation as to why that was. Did the judge call her in to have a word? Has her own firm said this is not helping? So yeah, it's been interesting to watch. I must confess, I find it a little bit distasteful. We have to live with disappointment, and sometimes it is better just to sort of take it on the chin, say, well, we respect the decision of the jury. Obviously, we disagree with their conclusions, but we have to respect their decision and keep quiet and just try and rehabilitate yourself.
Yeah, and I've seen comments there about hoping that Johnny Depp stays out of interviews, and I certainly hope that he does. I think he will stay out of interviews. I don't think he needs to. Certainly, I don't think he will. Likewise, same question. What do you think?
Yeah, I agree. He's got to just keep his head down, be dignified, have lots of pictures of him cuddling badgers, and just get on with his life. I do think, like I say, I keep coming back to this. I think tactically, it would be a good move to publicly announce that he's not going to seek to enforce the judgment without any conditions whatsoever. Just say, we're not going to go after the money. I just wanted to clear my name. That was all I was bothered about. I don't want to see her destitute. I am very happy that the world now recognises that I was the victim. That's from the PR point of view,
and that's fair enough. And I think that was really the intention behind the case, and he certainly achieved that. And certainly in the vote of public opinion, from everything that I've seen and heard, that's definitely the case from what I can see.
Well, that's the point. That's the point of defamation trials. Defamation trials is to rehabilitate your reputation. Because one thing you must remember about defamation is it's about reputation, not character. Because you've got this rather weird thing that somebody asked in one of your previous, I noticed a comment where somebody said, "Can somebody have such a bad reputation that you can't defame them?" And yes, they can. If I was to sort of say Charles Manson cheats at cards, he probably couldn't sue me. Because people are going to go, oh well, now I've heard that, my view has really changed. It's like to quote Norm Macdonald, the more I hear about this Hitler guy, the less I care for him. And there is an element of that in defamation.
It'd be like saying, Piers Morgan asks somebody some really difficult questions. Well, yeah, you can't exactly, it's
this
not
actually is
a reputation to say that, is it?
In my night lawyer days, this would crop up where there was a particular celebrity who had a reputation for cashing in on every aspect of their lives. And there was a story that came through that was sort of quite amusing, but it might not have actually been true. But we had a chat about it, and I said, well, look, from a legal perspective, I'll give my usual advice. But the fact of the matter is, would it make a difference? There's so many demonstrably true, occasions where this has happened, where they've just basically monetized their entire life. One more semi-amusing story is probably not going to make any difference to the public. And this was before the serious harm test came in. So there was a potential defamation case there just as of right. And that does happen, because like I said, it's not about what you're really like. It's about what the public think you're really like. And that's subtle but important.
Question here. This is about my petition, obviously. Percentage chance do you think the UK case will be reevaluated? Absolutely no idea, because it's so unheard of and it's so rare. This is really one of those where in our books, which you can probably see on my I've currently got a couple in here, the white books over there. In these books over here, there are some bits that say this will never happen, so we haven't really bothered writing much about it. And they cover virtually everything, these books. But this is one of those cases where you go and you look for some guidance, some instructive remarks, and there's just nothing. Because it doesn't happen. But that said, it's in the rules for a reason. So if it's in the rules, it's possible. And this, for me, ticks those boxes of being, well, it's unjust. There's no other way of saying it. It's unjust because we've now had this jury verdict, which totally blows out of the water everything that was decided here.
I had a
petition, by the way, the petition's linked in the description below. If anyone hasn't signed the petition, go sign it. We are we've got quite a number of signatures already, but I'll find out how many we've got. While you were saying, what were you going to say, Alan?
No, I was going to say, yeah, because I had a thing in the court martial appeal court because I once got stuck at a railway station in the middle of nowhere with nothing to read but a copy of the Armed Forces Act for about 3 hours. And I read it all the way to the end, and I spotted something in Schedule 7 and went, well, that can't be right because that's not what we've been doing. And it was all about something called stoppages, about, you know, if in a court martial, if you're convicted of something where there's a monetary loss, they can stop your wages to compensate the victims. And I read something, and what it actually said there was, it said, if you're going to go for stoppages, you have to do something, which was to name the damage on the actual charge sheet, which nobody ever bothered. And I thought, that can't be right. So I went to the court-martial appeal court with this, and they literally said, presumably Mr. Roberts was the only person since the person who drafted this who's ever read all the way to the end. And we succeeded on that point. And nobody up to that day had ever tested it because it never even occurred to anybody. You know, and it actually made quite a big difference to my client because it meant he didn't have to have like quite a few £1,000s taken out of his military salary. And I mean, once that was alerted, everybody just went, oh, all we need to do is just make sure we tick this box, and that'll never ever happen again. But yeah, the fact is, the laws are there for a reason, and we use obscure laws all the time. I think the oldest law I've used recently was something from about 1640, and that was to get somebody out of a personal guarantee, because there was this old statute, and it's in wonderfully flowery language of the sort of mid-17th century. And I said, but this is still good law. So actually, I know your viewers like sort of practical legal knowledge as well. That was the fact that a personal guarantee cannot be enforced unless the guarantor has signed it, because this was one where a company was chasing directors and saying, well, in our contract, it says all directors are personally liable for our fees. But the fact that one director on behalf of the company, they said that doesn't bind everybody else.
Doesn't watch. No. No, you're quite right. So here's an interesting question. Do you think she's doing this interview or these interviews in the hopes that the jury come out and say something incriminating before the appeal? Because potentially, is she baiting the jury into saying something that helps them overturn the jury verdict? It's a possibility. I mean, I wouldn't put anything past what's going on at the moment. Nelly, thank you for the super chat as well. Is it a good idea to reopen the UK? What if he lost again? Well, it can't make matters worse, really. I mean, the idea being if the appeal is, even if they were granted permission to appeal and then actually didn't do anything, that, in my view, would be enough for them to say, you know, we've granted permission to appeal on the basis that the jury have come back with a unanimous verdict. And I suspect that they might not even follow it up, cost reasons or whatever. They wouldn't need to. They've got their verdict in the States. Al, as you said last time, the court may say, well, you've had compensation out from the US, even though it's not the same defendants. That I can see your argument. The court saying, well, you've had, you know, it was awarded as 15 million. It's been curtailed, but you've had the award. So who knows?
It's like in the Banks and Cadwallader, where the court said, even though you've lost, you actually have a judgment you can point to vindicate your reputation. And I could well see that the appeal court could say, well, Mr. Depp, we appreciate what you're saying, but if Mr. Depp seeks vindication, he can point to the US verdict. And that would be a sort of tacit admission by the court that maybe the UK decision should no longer be relied upon, without them actually saying, yes, we'll reopen it. But like I say, the law will only allow you to bring a case if you can get something out of it. You know, nobody's allowed to bring a case just to prove a point or just to make themselves feel better or for personal vindication. You have to have, you know, it's this idea that the court will not act in vain. So if there is an alternative remedy and they say, okay, we appreciate what you're saying, you can now waive the US verdict to everybody. That's a tacit admission that it superseded the UK one. Yeah.
Asking about your Twitter, Al, I think it's House Chambers is the tag, isn't it?
It is, because I'm not very good at Twitter, so I just Coach House Chambers, which is as a lot of barristers do, where we're in chambers I'm in Goldsmiths in London, but I also have my own little boutique niche thing which I call Coach House. The funny thing is, my Twitter handle is one letter removed, because it comes up as House Chambers, and unfortunately the House of Congress in the US, their Twitter handle is House Chamber. So every time, at one stage I was going, why are you saying this? I have no control over
Yeah.
whether I can impeach Donald Trump. Stop asking me.
Fantastic. Thank you, Heidi, for becoming a channel member. As channel members, all your comments will stand up, because when I go to my back end in YouTube, you can filter by who is a channel member, and I look at those first. Those can inspire new videos. I can respond to comments. I can make new videos to answer questions, and you get to see all of the live streams all over again, and the catalog of previous live streams. There's hours and hours and hours of live streams that I've done for a long time. I've come back to doing them now. I took a break from them, but thank you for becoming a channel member. That join button is below. So thank you very much for that. Interesting point here, just jumping as an aside, therapist notes are hearsay. Very clear rule, not be admitted. Absolutely. Anything written, a lot of people have sort of got confused by this. Hearsay, it's actually, it's one thing a lot of law students struggle with, let alone everybody else, but it's just anything that is not said by a person in court. If you go to court and say, this is what I saw, coming words out of your mouth, that is oral evidence. Anything else that is not that is hearsay, if it's to prove the truth of the content. So you might have heard, in respect of some of these notes and some of the, some of the notes, some of the writing, some of the emails, there's an objection that it's hearsay. And occasionally, Elaine or Camille would have said, we're not seeking to prove the truth of the content, just that it was sent, or just that the conversation took place, just that there was an email sent and received, and so on. And then obviously it takes it out of that remit of hearsay. But in the civil courts in England and Wales, hearsay is permitted as long as you tell people you're going to rely on it. It's permitted. And this is one of my beef with the judgment. I know we're going full circle here, but it's one of my beef with the judgment is, if you've got a witness in court, you should take their testimony as being more important than hearsay. And throughout the judgment, there are bits and pieces where the judge has said, well, this is said by a person in court, so I trust it, even though there's audio recordings and video recordings of stuff that directly contradicts what's being said in court. Whereas the other way around, it was, even though they've got 3 witnesses in one occasion for one bit of evidence saying the same thing in court, saying, well, someone else wrote a message about this sometime shortly after the event, which is hearsay. But because someone else wrote it and it was shortly after the event, I take that to be the most credible version of events. Why is that? You've got 3 people. If you use the same analogy as what someone says in court is the most valid evidence, the most reliable evidence, why rely on the hearsay in one case but not the other? Surely the fair approach should be the same approach, the same application of the rules of evidence all the way through. But there we go. That's my beef with that. So that's the hearsay bit. Anything else you want to say on the hearsay, Al?
Yeah, I was going to say, because one thing that people struggle with, I mean, first of all, there are so many exceptions to the hearsay rule. I mean, in US jurisprudence, they talk about 27 exceptions. I mean, I don't think you can actually categorize them that well. But interestingly, what a lot of people forget is it's only hearsay if it's admitted for the truth of its contents. And this is a very interesting thing that showed up with the difference between a jury trial and a judge-only trial. And I think this is when, remember when Amber Heard said, oh, I was feared for my sister because I'd heard the rumors about him pushing Kate Moss down the stairs. And everyone said, oh, why are Brown Rudnick suddenly all excited about this?
Yeah.
Now, here's the interesting thing. What that did was, that opened up them to call Kate Moss to say it never happened. However, strictly speaking, that wasn't necessary, because all she'd said is, because I'd heard rumors. Now, that was not evidence that those rumors were true. And a judge would have just filtered that out and said, okay, you reacted in this way because of something you had been told. Whether that something is true or not is irrelevant. It's just to show your reaction. And a judge would have just filtered out and said, the mere fact there are rumors is no evidence that it happened. However, for a jury, those sorts of mental gymnastics, what they said is, well, now you've said that, even though you're not saying the rumors are necessarily true, they've heard that. There's a danger they may think that actually bolsters.
Actually, it's true. Yeah.
So they allowed Kate Moss to come along and say it never happened. But strictly, that wasn't an issue in the trial, because even Amber Heard wasn't saying it happened. She was just saying, I'd heard it happen.
I heard rumors of it, which is interesting because, as you say, strictly speaking, the judge could have, should have directed the jury. Now, you remember this bit of evidence? Well, you know, that was just a rumor. It wasn't said to be true. There was no evidence that it was true, so you should discount it. But because they've heard it, it gave rise, and you saw Ben Chew turn around and say, yes, because they wanted, because not only, as Al just said, not only was it not necessary to bring in a rebuttal witness to say, excuse me, that was me. It's not true. Didn't happen. It wasn't necessary. But what it did do is it allowed additional evidence to yet further show that what she was saying was untrue.
Yeah.
Because she said, I heard rumors that this happened. And again, it's her, regardless of whether it was true or not, it was her saying something that happened. And then someone else came in and said, no, it wasn't. And so this is like coming back to the point of the interview. Lots of bits and pieces that I've pulled up in the interview. If anyone hasn't caught those, I've done a few videos on these points, which you can find it. Make sure you subscribe and find them. But I've done lots of videos on these points, and little points, little things that she's said have indicated to me, in my opinion, personal opinion and legal opinion, if you want it, but little things that she said indicate the truth of what she was really saying or thinking at those times. So the idea that she's, just to recap a couple of them, full breakdown in my video, but she's lending her voice to this movement. Well, your voice would be part of the movement. If, like my voice, I'm a martial artist. So if I were to say, I am speaking for the martial arts world on a particular issue, okay, let's say I'm talking about it, I would say, as a martial artist, I am one of this group that wants this to happen. You know, I am one of these people, and I want this to happen. Not, well, I'll just, I've been paid to. The complete contrast is when you've been paid. You get a hired actor. You get the typical thing. You will all know it. You'll all recognize it. You'll see somebody that you've seen in a TV show or a film or whatever, or football player say, these crisps or this wine or this whatever is the best thing that I've ever had. And you think to yourself, really, you've just been paid to say this because, you're obviously a paid actor. You've appeared in the advert, whatever. That's kind of like lending your voice to something, isn't it? Only in that case, you're selling, you're signing a contract to say this on behalf of that company, right? That's pretty much what it is. So the way she phrased it to me is exactly that. But my latest video just coming out, is there a truth within Amber's truth in that the op-ed wasn't supposed to be about him? It was supposed to be just a story to support the movement, and she's lending her voice to it. So is there a poetic irony there that she's thinking, I know what this was really about. It was never about us, me and him. It was about a fictitious story about me lending my voice to this movement. But it was defamatory because the only person it could have been about was the person that she was married to. And that's why it was defamatory. But was there a truth hidden with that? Let me know in the comments what you think. Firstly, whether you've seen the video. Secondly, whether you agree with what I've just said. While I bring the super chat on screen and read it, while Al responds, because I can tell Al's desperate to say something.
No. I was just thinking because ironically, you were saying you just talked about endorsements and things like that. And just to give some little interesting defamation trivia, there's an old defamation case here where a chocolate company just featured an advert that had a golfer in it. They didn't seek his permission or anything like that, but this was in the old days before trademarking and things and proper sports endorsements. So they just had a picture of this golfer and their chocolate bar. Now, at the time, golf was very much an amateur game, and there was this gentleman versus players thing, and the golfer sued on the grounds that people reading that might think he had done a commercial endorsement, and that breached his amateur status, and he actually succeeded in the defamation claim. There's some weird defamation claims out there. Somebody succeeded in a defamation claim because Madame Tussauds put his waxwork near the Chamber of Horrors. and
Wow.
because he'd been acquitted of a notorious murder.
Association, isn't it?
Yeah, so so he'd been actually acquitted, but they still put him next to like Dr. Crippen and Jack the Ripper and everything like that, and he sued because he said the implication is that I am guilty, and he succeeded on that. So you can defame somebody not just through words, whether written or oral. You can defame somebody just by something like that. So you got to be very careful.
Lots of different ways. Absolutely. This is a very interesting question. Thank you for the generous super chat. Will I be covering the therapist notes as new evidence today? Like, yes, absolutely, I will, because I think there's going to be a lot of interesting things within there. And whilst she may think that it'll be positive in her favor and say, look, see everybody, this is what the therapist wrote down when I was sitting there, saying everything, and without being disrespectful, because I'm not. But what that will say is this is what was said to the therapist, and it will reveal, I dare say, it will probably reveal what her real thoughts were and the therapist's views on it. And I have reached out. There's a number of therapists and psychologists that have contacted me to come and join us on a live, which I'm going to arrange. I have he's been busy for a couple of weeks, so hopefully next week, everybody, I should hopefully have a consultant forensic psychiatrist joining us on a live, and hopefully Al, you could join us for that as well, because I'll be very interested in what his views. Dr. Shaham Das, he has a YouTube channel as well. It's called a
Dan, you've got one heck of a buzz there. I've just muted my microphone and I don't think it's me. That's better. The buzz has gone, but unfortunately, it sounds like you're on mute.
How about that? Can you hear me now?
Yes, we are now fully functioning again.
Right. I don't know what happened there. I didn't do anything. I didn't touch anything, but hopefully we're still here. Right. Yeah. So no, I was saying, hopefully we should have a psychiatrist with us next week to discuss this further. What are your thoughts on these notes? Al, have you had any thoughts on these therapist notes yet? What they might reveal?
I've only briefly just seen that they've come up. I mean, there's a couple of things here, because actually when you've got Dr. Das on, it'd be really interesting to talk about the Goldwater rule, because obviously that cropped up in the trial as well. And I think that's a fascinating thing about, we've discussed a lot about what lawyers' ethics are and code of conduct. And this would be very interesting to see from a psychiatric point of view, because they have a very strict code of conduct as well. And that'd be interesting. But yeah,
just explain to people what that rule is. Most people won't know what that rule is.
Okay, the Goldwater rule, in very, very basic terms, and this is how I would cross-examine Dr. Spiegel, it says that, generally speaking, psychiatrists and psychologists should not proffer opinions or diagnosis on people who either aren't their patients or they haven't at least examined personally. Now, the rationale for that is, first of all, it's unethical, because there's a guy called Barry Goldwater running for election, and basically a bunch of psychiatrists published lots of opinions saying this guy is completely loopy and unfit for office, etc., just to smear him effectively as part of a political campaign. And they'd actually some people had broken in and stole his doctor's notes. It was all very, in the true Watergate tradition. But
Yeah.
you can understand that what they're saying is, first of all, it's unethical, but also it's unreliable, because unless you have physically spoken to somebody, examined them, run all the appropriate tests, because there's lots of psychiatric tests and things, that you just cannot make the same level of assessment just by remotely viewing somebody else. I mean, in practice, people do breach that rule occasionally. Because it has to be done. I mean, psychological profilers will do that. Now, whether or not you think psychological profiling really works or doesn't, they'll say, well, we suspect the suspect we're after will fit this profile. That's not a breach of the Goldwater rule, because it's got a practical purpose. But generally speaking, whether it's just in the media or even in court, the rule is that people shouldn't express opinions, medical diagnosis, on people that they're not in a position to do so. And I'm sure people can understand the rationale for that. But very interesting to hear a psychiatrist's perspective on that.
Absolutely. And so for that reason, and for that very rule, you will always hear, unless it's a professional opinion being given, say in court or something like that, if you hear a psychiatrist giving an opinion, they will always clarify, now, I haven't had the opportunity to assess this person. Just as you hear me say all the time, I haven't had the opportunity to sit down with you, discuss with you your case, ask you questions and this sort of thing. Therefore, nothing that I say can be taken as legal advice. For example, it's exactly the same thing. I can give views and opinions and all the rest of it that's fine for us. But exactly when you're doing that as a psychiatrist or a psychiatrist or something like that, then yeah, of course, it's got to be qualified. And sorry about the buzzing. I don't know what happened there. This setup's been the same for a long time, and today it's given me every problem under the sun. So I apologize, but there we go. Yeah. Hopefully we're okay now. Hopefully we're still okay. Do let me know in the comments if I'm not okay. This is it's not exactly a cheap setup either, but there we go.
With the notes themselves, by the way, just one little thing.
Yes.
Again, more exceptions to the hearsay rule. Other exceptions are to prove a previous inconsistent statement, and also what we call statements against self-interest. So if the notes contained anything that suggested that were different to what a party was now claiming, you could point to that and say, yes, well, but on a previous occasion, you told somebody something different. And that's what we call previous inconsistent statement. Previous inconsistent statements are admissible. Previous consistent statements aren't, because they say, well, look, the mere fact that you went around telling all your neighbours, I did not rob that bank, it doesesn't really assist us. But if you
matter,
yeah.
But self-serving statement is another way of putting it. It doesn't matter how many people you tell that you would never rob a bank or you didn't rob the bank. If you're arrested and there's evidence that you did, it matters not how many people you told otherwise.
Yeah, but a statement where you told your neighbours, yes, I did rob that bank, is admissible, because the argument is, well, why would you say it if it wasn't true? You
wouldn't say if it wasn't true. Absolutely. Coming to this super chat from JJ Girl, not read it yet, so I'm reading it live on screen. Wouldn't Amber have been able to get some of the therapist notes in via Dr. Hughes? She had access to all the therapist notes and talked about them. There'll still be hearsay, really. Either way you look at it, there'll still be hearsay. So there'd have to be, at the very least, a significant relevance which can be proven. And even then, seeking to prove the truth of the matter, it would still be hearsay. Saying that she made notes would be okay. She's referring to it. But the point you got to remember is this: if I want to convince somebody that something happened and I previously talked about it with somebody, so bearing in mind, let's take a hypothetical situation where somebody went to see a therapist and made it all up and told the therapist, and then later on you end up in court being sued for defamation or something, and you want to bring those notes into court to prove that that's what happened. It's hearsay because you're trying to prove that it happened by virtue of what's written in the notes. That's why it's hearsay, because it can't be tested, because it was written down either by you. Even if it's by you, doesn't matter who it's written by. It could be a child drawing a picture a child. I've had one case. Here's an example of hearsay that was excluded. I've had one case of a child drawing a picture of one person hurting another with, one parent's name pointing at one party. And I'm being very political here. And that was deemed to be hearsay because it was seeking to prove that one party was hurting the other. Now, who's to say whether that was true? You can't test whether that's true or not. No one, you can't cross-examine a piece of paper and a drawing and a handwritten scribbled note. You can't cross-examine it. Cross-examine is obviously testing the evidence. So the test is, if Al tells me, I saw this person attack somebody across the road yesterday evening, and if it was written down and that's it, no more, and that's the only thing you have, you can either believe it or not. So you've got a choice to believe the truth of what it says or not. If Al comes to court and says that to me, and I say, Al, yesterday evening, it was late, wasn't it? Yes. It was dark, wasn't it? Yes. You were some 50 meters away from this person, weren't you? Yes. There were cars going by. There were people going by. It was raining. It was whatever. And then my conclusion, we always build it to a conclusion. My conclusion in there is, you can't be certain that it was him, can you? And I might say, he won't usually, but he might say, well, no, when you put it like that, no, I can't be certain that it was him. Some people still say that they are certain, even though it was all those things, far away, dark, raining, and whatever. The point is this: you've been able to test the evidence. And so regardless of what Al then says, the judge or the jury, depending on the case may be, can make a judgment as to whether or not Al is telling the truth, or not just telling the truth, whether it's reliable.
Right.
Al might be absolutely certain, excuse me, that it was this person. He might still be certain that it was him. But how reliable is it? Because I've tested it. And that's why hearsay ultimately is less reliable. You can't test it.
Well, you mentioned Turnbull before, and that was a case where the most convincing witness in the world gave some evidence to ID, and somebody was convicted, and then later on it was demonstrably proven that it just couldn't have happened. And this was a completely honest witness. Nobody suggested this witness was making it up. It was like, you genuinely believe that, and yes, you were very close. The blind conditions are perfect, so that's why we do. I mean, ID evidence is always considered to be a bit sketchy, to be perfectly frank, just because with best money in the world, it's not reliable. But just to come back to the other point about hearsay and previous consistent statements are generally inadmissible. However, and this is your viewership now are getting some really hardcore, in-depth legal stuff that you don't even normally get this on like law degrees. This is the real practical stuff. One exception to that is to disprove an allegation of recent invention. So say, for instance, normally if I'd written like Joe Bloggs beat me up, and I've put that in my diary, and I want to put that in my diary and say like, I want this as evidence. Well, it's irrelevant. It doesn't matter what you've written. There's no evidence there. If, however, I'm in court and somebody says, why were you scared to go down to that house? Oh, well, Joe Bloggs beat me up. No, he didn't. You're just making that all up. I can then pull my diary and say, no, I've been saying this for months. And that's one of the exceptions to previous consistent statements, is to disprove an allegation of a recent invention. And that does crop up a lot, especially with like alibis and things where people say, you're just making this up now in the trial to cover for yourself. Then you can actually, and this is why we always say, never ask a question you don't know the answer to, and don't take risks, because you can end up asking a question that seems to prove a good point, and suddenly loads of evidence that was previously inadmissible is now admissible. And that's why I keep coming back to Brown-Rudnick's fantastic trial strategy, which is
absolutely
do the absolute minimum. You do not win trials by being good. You lose trials by making mistakes. So minimize the opportunity to make mistakes. Slow and steady. And that's why Camille Vasquez, some people have criticized and said, oh, she was very plodding and she just, she went through everything and it was like, very tedious, and she was very,
that's how it needs to be.
But that was safe. You've seen what happens.
Safe, careful, meticulous, step by step. And you will have heard her very often say that was not my question.
Mm.
My question was, and then repeats the question.
Yeah.
And that's because you absolutely must get a response to the question you really asked. And when new lawyers are starting out, they'll be afraid to push a witness and be afraid to say, interviewers are brilliant at this. Piers Morgan, absolute perfect example. You know, Piers Morgan would make a better lawyer than 90% of new lawyers. Because if you just tell him, these are the questions, this is what we want to find out, this is what they need to say, this is what we don't need them to say, go and ask them questions. He will do a fantastic job because he's not afraid to ask the question. And you've got to press for that answer. And just coming back on another point about an honest witness being mistaken, there's a fantastic little clip. I'm going to turn myself and Al off, and I'm going to show you. I'm going to take that off the screen. I'm going to add this to the stream and let you watch this. It's from this channel. Actually, I'm just going to add myself back in just in case you can't hear me with all the foul ups that we've had so far. When you watch this, try to spot how many things change in this scenery. Count them up. Let me know in the comments how many things you see change in this few short seconds. And then you'll see it after. Right. So how many things did you see change? And now you're going to see frame by frame the before and after. Look at that. So let me just grab freeze frames. So that's after, I think. The second frame, that's after. And that's before. Look how many things have changed now. So an honest witness can be mistaken. They can say there was absolutely, most definitely a blue coat on the sofa or whatever. And yet they didn't see it disappear or they didn't see it change. And so that's what we've got here. We've got a whole catalog of different witnesses. And I didn't get to it. By the way, Gareth, I see your super chat. I will come to you in just a moment. One person said, and I respectfully disagree with you, but one person said a psychiatrist's views in court are no more important than anyone else's. To some extent, you're right in that they are just coming to give their evidence and their opinion. But the slim element that I disagree with is that if most people come to court and give their opinion, for example, I think she's crazy, for example, is the way some people might put it. Whereas a psychiatrist would obviously put it in more professional terms. And most importantly, it will be a professional opinion. You will recall that at the outset of all the professional evidence, opinion evidence, they spent 5 or 10 minutes talking about all their qualifications, how many times they've given expert reports, and so on and so forth. That is to stand them out as an expert in their field, so that when they give their opinion, their expert opinion, it's relied on. Because ordinarily, I've sort of coined a phrase, no one cares about your opinions and no one cares about your emotions, save for very narrow circumstances. And one of those with opinion evidence is if you're an expert. So with that, I will come to what Gareth says, whilst Al makes any response to that, if you've got anything to follow up, Al.
No. I mean, there's a couple of points here. I mean, first of all, actually, there's one. It's not an exception to the lay witnesses can't give opinion evidence. But for instance, say you're in a case where somebody say you say, I saw him and he was drunk. Well, technically, that is opinion evidence, and you're not qualified to do that. But what you can say is things like, I saw he was unsteady on his feet. I could smell alcohol in his breath. his words were slurred. And you actually, they will let you say, he appeared to me to be drunk, because what you're not saying is, yes, he was drunk. You're just saying, again,
he was definitely. And there's a legal and very technical distinction there. You know, if let's take driving and being over the prescribed limit for alcohol for driving. If someone says he was over the limit, you can't say that. You don't know. You don't know whether he's over the limit or not. What you can say, he was staggering all over the place, slurring his words, and he couldn't possibly string a sentence together. Therefore, it appeared to me that he'd had too much to drink to be able to drive. That's a different opinion. Yeah. Legally speaking, it's a different opinion.
Yeah, because the other side can come back and say, well, actually, no, he's got MS, or he's got a disability, or he just had a stroke or something like that. But all you're doing is you're giving because that's real evidence. You're not saying what the definite conclusion is. You're just saying how it appeared to you. And that, again, it's one of these subtle distinctions that, the rules of evidence are probably a lot trickier than the actual substantive law about offences. But you do sort of get, after a while, you get intuitively. You know what the limits are, and you know what judges will let you, and where they will draw lines.
And it's normally a bit flexible as well. It's normally not a hard line cut-off point, and it's normally there are a few grey areas. But Gareth, I agree with you. As a psychotherapist, counsellors will generally accept what a client says, and on the stand will say, "I've no idea whether it's true or not." And maybe, just maybe, that's what some of these notes might say. She told me that this, that, and the other happened. I don't know whether that happened or not, but she appeared to be upset when she was talking about it, etc., etc. That's probably what it says.
One thing I'd like to discuss with your very learned doctor friend is I went on a Hi, Caroline. I went on a really good course once where it was all about the psychiatric and psychological tests that we use in the legal profession. And it was so we could understand them better. It wasn't so, I am not qualified to conduct the WACE 3 test, but I know what it is, and I know how to ask questions about it. But that was really interesting because they actually did a lot of the tests on us. And as people keep pointing out, I did the WACE 3 IQ test and I scored 73. No, I think it's scored 68, which was only 3 above actually being fit enough to stand trial myself. And my argument was that IQ tests don't test IQ. They just test how good you are at doing IQ tests. But what's interesting is one of the tests we did was about mental incapacity. And the tests have built-in tests to spot if people are trying to fake the test. Because people might have a vested interest in saying, "Oh, I am not fit to stand trial," or I am not mentally competent to be sentenced. And they do have tests in there. There was one very interesting one we were doing. So some of these questions are really interesting. And
I know which one you're going to talk about.
I'm going to talk about the Trump test. Yeah. Because Trump said, "I passed all these questions." And those are the questions they ask to see if you're faking it. Because even if literally you've had a physical brain injury and you've lost half of your cerebellum, you will still get those answers correct. But people think, "Oh, I need to look like, I need to look really mentally incompetent. So, oh no, I can't tell how many fingers and I can't tell what animal that is." And it's like, well, and if interestingly, Dr. Curry went in about and some of the other experts went about the malingering, as they call it, which is, slightly different. It's a pejorative word, but it has a technical meaning. And you'll notice that actually, so it's, yes, they will, to a certain extent, accept what their clients tell them about factual matters. When they run the tests do have mechanisms in to see if people are trying to fake it.
Yeah, absolutely right. Quick super chat here, Gary Radar, if that is your real name. But thank you for that. Can you get a DUI? Obviously, driving under the influence if you're driving a ship. I don't know the exact law offhand, either in the States or in the UK, but I can almost guarantee that there will be one. There will be some kind of law, some kind of rule, some kind of regulation. There will be one which is virtually equivalent, if not more stringent, because of the size, the nature, and everything else. So almost certainly yes is the answer to your question.
It's also an offence to be drunk in charge of a horse or cattle.
Indeed. Absolutely. There is another super chat I'm just looking for at the moment. Let me hunt you out. I've got to scroll up and down to find these things. This is why I tried the better software, which turns out not to be better, but there we go. Bali, thank you for your kind super chat as well. if Johnny doesn't collect his 10 million judgment, I guess she can still collect it. Well, actually, yeah, that's sort of how it needs to happen. But I'll hazard a guess and say that they're not going to pay that in a hurry because they know that she owes them and she can't pay them. Does that make sense? Because here, what would happen is we'd have a set off. We call it a set off. And that's, to my understanding, not how it works in the States. In England and Wales, if there's a claim for £10,000 and there's a counterclaim for £5,000, and the judge says, "Do you know what? You both win," then there'll be a set off. The 5,000 will be set off against the 10, and so 5 is owing. So there's no point in paying across the 5 and the 10 and whatever. It will be just the set off amount, the net amount. Here, in the States, I understand that it doesn't work like that, but I also will hazard a guess and say that in practice, they're not going to be in a hurry to pay it across. That's just my sort of gut feeling. I don't know. Do you agree with that, Al? It's a pure guess, but that's
because technically there are 2 separate judgments. There's a judgment on the claim and a judgment on the counterclaim. So even if Depp said, I am not enforcing my claim, the other side could come back and say, well, we're enforcing our claim.
We're enforcing ours, yeah.
Then again, because judgments create they would probably have to sue on the judgment, and then you say, well, I've got a defense because I've got a set off. But then they might say, well, you agreed to write it off. But gratuitous promises aren't enforceable. There's this thing called promissory estoppel, though, where if you promise to do something and somebody acts to their detriment as a result of that promise, then you can actually enforce the promise, even though it's not a contract and there's been no consideration and all that sort of thing. But you have to act to your detriment, and it's very difficult to see what the detriment would be. I mean, it could be. And
just to explain that,
sorry, I was going to say it could be
another. Go on.
No, I was going to say, for instance, the thing was, I won't enforce the judgment, because I understand, she's not going to appeal. And there was no formal settlement agreement saying that. It was just people had just said things in the media. And so he said, oh, well, basically, because Johnny said he wasn't going to enforce the judgment, I've decided to let this drop. But then he came back years later, after the time limit for the appeal, and said, actually, no, I do want my 10.3 million. I said, well, hang on a minute. We've abandoned our appeal. Well, we never put anything in writing. That would probably give rise to a promissory estoppel, because giving up your right or leaving it too late to appeal is you acting to your detriment on the basis of a promise. And that's one exception to the normal rule about contracts, that there has to be consideration and you can't enforce gratuitous promises.
Yeah. So someone acting in their detriment in response to a promise, even though it's gratuitous, normally a gift or whatever, like a gift to not enforce the judgment would be a gift in any other sense. But if someone acted to lose out because of that, and then they come later knocking for it, I'd agree with you on that. Justin Thomas, thank you for your super chat. Amber in the UK and US said it was unforgettable that abuse began in 2013. Team tried to reverse course to get 2012 in. Judge sustained and answered objection. Very good point. There is another super chat. Let me find. Sarah Adams is a therapist and understands the situation. Yeah, quite right. You can get a DUI on a bicycle in some states. Same here as well. We call it wanton and furious driving.
Yeah.
Some very interesting, very old English language drafted into the legislation there. Here's a very, very interesting ethical question. I thought it was illegal for doctors to not report abuse. Thank you for your input. Thank you for your comment and your super chat. Very interesting to hear the differences between UK and US. Love from Florida. Welcome from Florida. I am yet to visit Florida. I'll be there as soon as I can, I promise you. So there's a very interesting question here, and there's a very fine line between what can, cannot, must not be reported by doctors. So very generally speaking, there's a fairly universal application to this rule, which is as follows. If there's immediate harm, they need to report it. So it's probably the only exception that would cut through a lawyer's confidentiality. So if you were hypothetically in a conference with someone who was accused of murder and they said, yeah, I did it, but you can't tell anybody, I'm pleading not guilty, then you can't, as the lawyer, you must not ever break that confidentiality. You'll be disbarred like that. That's it. Game over. However, if they got out of the conference and said, because he's impugned my integrity, well, obviously wouldn't say that, because he's attacked me, because he's insulted me, I'm going to go and kill him right now, and got up and walked out, and you genuinely believe that he's going to do it, you got to call the police, because their life's in danger right there and then. You can't just sit back and say, well, lawyer confidentiality, he told me in conference, therefore it's confidential. That's probably one of the only times that it will cut through that. If it's immediate,
I'm not sure about that. I think the only thing we are obliged to report is certain offences under the Terrorism Act, because just to get all boring and technical, we used to have an offence here called misprision of felony, which was not reporting if you knew a crime was about to take place, and that was specifically abolished. And it's an interesting one about the ethics thing. I'll be honest. If somebody sort of said, right, I'm off to stab him now, this is terrible. This, I'm sort of going, it's an ethical, right?
It's an ethical dilemma.
DSB,
yeah. It's immediate harm, and I make the point because I think it's the same. I think it's the same for doctors. I think if it's doctor-patient confidentiality, it attracts the same level of prejudice.
I think doctors specifically have and especially therapists, you must report if there is a risk to I think the test is imminent and serious harm to third parties. So merely somebody sort of going, I've got very dark thoughts about somebody, and sometimes I think about doing X, Y, and Z. I mean, this is totally out of our wheelhouse, and that's why it'd be interesting to actually get the doctor on to see what they say about this, because a lot of ethical judgments are judgments. I always say when we do the ethics course, I always say to the students, look, there are very few ethical problems. All the answers are in the BSB handbook, even though it's unnavigable. Most ethical problems are, I'm going to have an awkward conversation with somebody problems. I always find it's like, I'm going to have to say something to the judge or my client or my solicitor, I'm going to get yelled at. But yeah, that's a genuine ethical problem as to, because we've discussed this about, we don't have to give knowledge about a crime. I had one, I've got to be careful what I say here. But I had an old client who came and said they were looking. Somebody was on. There's effectively a police appeal for like crime watch thing. Do you know who might have been on it? And somebody approached me, one of my old clients, and said, "That's me. They're looking for." And it's, what do I do? And he told me a certain version of events. I said, well, arguably you've got a defence there, but it was a big thing. And I had to say, I said, actually, it's not for me to sort of say tactically what you can do, but legally I don't have to report you, and legally you don't have to hand yourself in. It's for them to catch you and prove it. And that was a very interesting, I mean, we did have a chat about the practicalities as to whether, because he had a defence to the most serious crime, albeit something went wrong in a less serious crime. That was a real ethical dilemma as to not so much because I knew I didn't have to report him, but it was what advice should I give him that was in his best interest? Should he just go to the police and say, look, I'm the guy they're looking for, but this is how it happened? Or should you just keep your head
no, exactly. Interesting point here with very important point they keep making is about social media. Does it matter? Well, the point is this. We trust the jury, and I hand on heart, not just because I'm a lawyer and I'm signed up to the system, as a lot of people think, but I genuinely believe that juries are not swayed by, let's just call it, stuff that they read online. I genuinely don't think that's the case. I genuinely trust that the jury will go through the evidence, they'll go through it properly, they'll discuss it properly, and I'll discuss only the evidence, and only, let's say, that there was one bit that they were told to ignore by the judge. I think they really will ignore it, because I've seen jury verdicts where the judge has said, now I know that this, that, and the other makes it look like this person really should be punished for this. However, if you find that this is the case, then you must acquit this person. And they acquit because they've been told that this is the fine line within which they must come to their verdict, and they do. So, yeah, with respect to social media, in my view, social media was a response to the public trial. I don't think the jury would be swayed by it at all. And even if one person was, or even two people, or even three people were, they wouldn't come to a unanimous verdict.
No.
It would skew the full deliberations, and that's my view anyway. Couple more super chats. From Gareth again, thank you. Psychotherapy wording is, if there's a risk to you or someone else, we might have to break confidentiality. Suicidal thoughts alone aren't enough. Yeah, I'd agree with that as well. Because suicidal thoughts, again, it's still within the realms and the remit of your therapy. I would agree with that. So yeah, I mean, I'll look this up afterwards. I'll be interested, because from my understanding and certainly recent training, the only one that comes outside of there is immediate and serious risk to life. Then it's a case of, well, you've got to at least tell the police, not necessarily who and whatever, but I will look this up. It's an interesting point.
I'll ask around as well. I mean, it's tempting to ask the BSB, but I think they're getting fed up with some of my emails, because I will literally email them and say, okay, I am about to go on a protest and a demo, and these are the list of things that we might do. Can you just tell me which offences you are cool with? And they're like, no.
Yeah.
See what happens.
I just had a quick look in the handbook. There's nothing that talks about immediate harm and threat to life, and nothing in there. I think, and let's put it another way. If there was take the scenario where the threat was made, you made the report to the police arrested someone trying to take someone's life, and then he said, well, he shouldn't have told the police about it. I can't see the regulator coming down on you for saving someone's life. It'd be absurd. So if you think it through, most things that make sense would be the right one. Let me come to the super chat that I just missed from Bethan. Thank you very much. I don't know if you appear to be from Denmark. In a case in Denmark, a mate was convicted for manslaughter with particularly aggravated circumstances because his drunkenness resulted in a ship's collision, but not sure that he was charged with being drunk. Whether he was charged with being drunk or not, clearly that would have had an effect. And there probably is, almost certainly an offence of being drunk in charge of a ship, or having something to do with the control of a ship, what we call the speed and direction of a vehicle. So even if for example, you're standing outside of a vehicle, but you've got your hand through the window and you're steering it and you're walking along while it's moving, and then it injures somebody, you're still in control of the vehicle. Thank you to Heidi as well for your super chat. Thank you for explaining things so thoroughly. Thank you to you for listening. If you haven't gathered, we love talking. Al and I are probably kindred spirits in the sense that, well, for one, we're barristers, so we like talking. There was a thing on TikTok a few weeks ago that said, for everyone that was told to be quiet in class, what is your story now and what do you do for a living? And I said, well, I'm a barrister. I literally get paid to talk. Yeah. So yeah, we like to talk and explain, and I'm glad that you find it useful. Confused about how the Amber interviews continue spreading abuse allegations when this is already tried in court. What's truly considered defamation? So I did address this in some of my videos, at least one or two of them. If technically speaking, if she republishes her previous defamatory statement, technically speaking, it gives rise to a new case for defamation. Although, as Al's previously mentioned, and I mentioned in my videos, the issue of estoppel, which is, think of it as stop because you've done it before. So I don't know if you could phrase it any better than me, Al, but I think I explain it as estoppel, the principle of estoppel or collateral estoppel, as just stop right there because we've done this before. We've been there before. A little bit like you can't be tried for the same crime twice. You know, you get tried for a crime, you get acquitted, they come back and say, well, now we've got the CCTV, so now we're going to do it all over again. Well, that's not fair, is it? You had your shot, and it's tough. So in one sense, the issue of estoppel comes up.
Yeah.
In another sense, it really depends on what she says next, because at the moment, she's skating on the same bit of ice, really, in that she's repeating the same things. She's saying again that he's lying. She's saying again that she's telling the truth, which is tantamount to the same thing. She's saying again that the testimony was true, that the op-ed was true, and so on and so forth. So in one sense, she's just saying the same thing again. And I say just because there's almost no point in a new suit to prove what they've already proven, which is most likely what the judge would say if they go back to court for what she's saying now. This will change if she does a book or a series, or, you know, like a Netflix series or some kind of explosive tell-all documentary docu-series in 10 times more detail. Then I think she's got a serious problem. Al?
Yeah, I mean, the estoppel thing is because two things the law search looks for is finality and certainty. Sometimes that can result in an injustice, but the idea is, look, eventually we have to draw a line on things and say, you've had your chance. Everybody needs to know where they stand so they can move on without the risk that a decision may be overturned. Because it's like, right, everybody needs to know, right, what can I do? I can move on with my life. And this crops up all the time in like commercial litigation, for example, where, you know, okay, what has the court ruled about who was right about this contract and who that belongs to and who this? Because people need to make decisions based on facts, and they need to know those facts aren't suddenly going to change after they've made a decision. So sometimes that can lead to injustice, but that's why it's very, very hard to reopen appeals and things, because it's like, sorry, we've gone beyond that now. And sometimes that can result in injustice. As to this, repeating the allegations is defamatory. But again, we've come back to this. It's only defamatory if it lowers the estimation of somebody in the eyes of the general public.
Yeah.
And probably most people have made their minds up now. So
yeah,
is anything Amber Heard saying actually going to affect Depp in a negative way? Probably.
Yeah. And in terms of you're absolutely right. I agree with you. And in terms of these interviews, no, because for one, it's just her reeling over the decision. For another, it doesn't change the jury verdict. And for another, you got people like me tearing it apart, saying, well, you know, here's what I think of this, this, and this. So yeah, overall, no. You'll look at, and the news coverage, even the way that the presenters ask the questions, you know when a presenter doesn't believe them. When you say, can't you see that everyone thinks this? It's another way of saying, well, you're wrong, but why do you say you're not? And they're giving them airtime, literally giving them airtime to say what they think.
And in the US, and to a certain extent here, it is a defense to a defamation claim to say, no, nobody in their right mind would believe me. I mean, that's literally the Tucker Carlson defense. He's been sued for defamation, and Fox News' defense is, no right-minded person would believe anything Tucker Carlson says.
Yeah, this is outrageous.
That's really throwing your presenter under a bus, but it is actually a valid defense. And I know it sounds awful, but I think a competent firm, if Amber Heard was pursued again, would do no right-minded person would believe her.
I'm quite right. I mean, if you
say about your own client, but it is a good defense.
Yeah, it's a bit like if I were to say, Al, you know, this verdict is all your fault, you know, and you know she should come after you for the money or whatever. It's like no one's going to believe that. It's quite ridiculous. So anyway, so it's a bit you can see why
I bet Johnny Depp wishes he'd listened to my standard advice on bringing defamation claims in the UK. Never do it.
Yeah, no, absolutely. Get the defendant right in the first place, but they had no choice really. They had to do something, and they you know, I'm sure they would have had discussions to that effect. But Mickey Spoon, thank you for your super chat. During the trial, I believe there was 4 testimonies of the stairs. That was incident 9. Of all of them were different. Do you know why neither team worked to resolve that for the jury? Well, in short, I think they put the picture together for the jury to see for themselves. Now, Ali, I'm not sure if you're familiar with the staircase incident. You probably are. But by all accounts, by certainly by witness account, Johnny was downstairs. Amber's account, I'm talking UK to begin with, because that's where most of my reading was. And then obviously I watched the trial. But by witness account, he was downstairs. By Amber's account, he was already hitting her and then came up the stairs, which didn't make sense. Witness account, he was downstairs and then came upstairs and tried to hit her. You know, Amber's account was he pushed Whitney and she was worried about her falling down the stairs. Whitney's account was that he was pulling her from behind. And then Amber's account in court in the US was that he swung at Whitney, and so she jumped to the defense. So yeah, there's all different stories and accounts as to what happened. I think Depp's lawyers thought, you know what, let's just allow the jury to hear every version of events, and we will cross-examine on those versions of events and let the jury decide. And the jury did decide, because honestly, if everybody was so minded, and I don't think they were with the UK trial, in all honesty, I think, this is my personal view now, not even a professional one. I do make the distinction sometimes. My personal view is not enough people were interested enough in the UK trial to be invested enough in reading the statements, looking for inconsistencies, and coming to a reasoned judgment on what happened on each of these 14 incidents. Of course not. Even an Amber supporter that I saw on TikTok the other day said she supports Amber. Depp shouldn't have won. But of course I didn't watch any of the trial. And I think, well, how can you come to that decision then? You can't. But the reverse is true as well. You wouldn't have known whether or not who to support unless you'd read these statements. So anyway, my point is, if I did take any individual, any ordinary, reasonable individual, and say, right, sit down, this is what Whitney said in her witness statement. This is what Amber said in her witness statement. This is what Whitney said in court. This is what Amber said in court. And then we had the US trial, and this is what each of them said, and so on and so forth. What do you think? I genuinely think any reasonable person on the planet with no sort of previous thoughts, notions, prejudice, experience, whatever, any reasonable person thinking about these on their merits would think, well, that clearly just doesn't make sense. All of that testimony is contradictory, doesn't make sense. Therefore, it probably didn't happen, at least not in the way that they said. That's what I think. Al?
Yeah, one thing to remember is a standard direction juries get is you do not have to resolve every issue in this trial. You only have to resolve the ones that you think are important to you reaching the decision that you need to do. Because quite often in trials, there'll be lots of issues where it is difficult to know one way or the other or make a decision. I mean, and just to come back to this idea, this relates to, you know, when we've said about putting your case, that if you disagree with a witness, you must, if you're suggesting something is incorrect or untrue, you must put it to the witness and give them a chance to respond. One thing we will quite often do in trials here, just to speed things up, and I will say this to judges, I will say, look, there's quite a lot in dispute here, but you may think that a lot of it isn't relevant to what we actually need to work out. So I also go, I'm sure I'll be forgiven if I don't put every point to every witness. And judges will quite often go, oh, yes, Mr. Roberts, carry on. And the great thing about that is when you get to the end and you make your speech and somebody says, well, that was never put. So you said I didn't have to. So you've got to be careful about where you draw the line. But yeah, I mean, no trial would ever, there's always issues in trials where you just don't know. There's inexplicable things. There's things where there's no evidence either way that can let you know what happened. But unless that's actually essential to the decision you have to make at the end of the day, you can just go, you know what, that's always going to be a mystery. However, we have enough evidence here to make a decision.
Yeah. And just on that point, Al, you reminded me of exactly that, where it was a personal injury case worth about £9,000 plus costs, which were coincidentally about £9,000. And the one bit that I hadn't put, because it was implicit in everything that I'd said, because he'd taken time off work, he'd lost money, his clothes were torn, and so on and so forth. And there was whole schedule of different things. There was about £9 or something that he'd spent on ibuprofen for, muscle pain and stuff like that. And my opponent, even though I sort of won hands down, tried to argue on this £9 that I hadn't put it as a point of costs. And the judge said, well, I'm going to give it to him.
Yeah.
It was just, it won the entirety of the claim. And the argument was that I hadn't put this £9 in evidence, not in evidence, in my submissions. But there we go. Drunkenness is a part that qualifies particularly aggravated circumstances, and it would seem that Danish law doesn't distinguish between motor vehicles. Yes, I'm Danish. Very interesting. And in fact, on that point, Bethan, excuse me, we have very broad law when it comes to vehicles as well, because we just define it as a mechanically propelled vehicle. So that's quite broad and all-encompassing. So, yeah, and the law for each of those is derived on the same principles. So if you're, in other words, if you're drunk and you're driving something, you're liable. That's the basic premise.
Well, I suppose that's quite handy because it saves all those arguments that either you crash your car into the sea or you crash your boat into the land and go like, was it?
Yeah. Wouldn't an injunction be easier than not necessarily. I mean, here, Al was telling us last time that here in England and Wales, there's a fairly common practice in these sort of claims to go for the injunction as well, not to repeat. And certainly I've dealt with many civil cases and many family cases where we get a fairly routine, actually, injunction. An injunction, for anyone that isn't familiar, you'll be forgiven for not knowing what the terms mean. An injunction is essentially just the court saying either don't do this or you must do that. That's an injunction. It's either prohibitory or mandatory. And in rare cases, a quia timit, which is a very rare breed of injunction, which I don't need to bore you with. But would it, well, for the States, I don't know. I think it's more difficult in the States to get an injunction for the same thing. It's more a case of, well, if they do it again, you sue them again. And there needs to be a repeat and then an injunction that follows. That's my understanding at the very least.
There seems to be more of a thing of you've won, you've got your money. Everybody can now make their own decision. Whereas here, there is a sort of we will claim for damages, but then we'll also claim for remove the article and no repetition. Yeah. But and I think because of this slightly different way in the US with the First Amendment and things. But the fact is that the court will say Mr. Depp can point to the jury decision, and that's his vindication.
Optimus Prime is now one of our members. So welcome to membership. That means you will get this live stream in full, start to finish as a member, because they go members only after the streams, as do all of my previous ones. And there's a whole catalog of stuff that you can get access to as well, which are not public videos. They're kind of legal training videos, which actually, Al, I'm yet to talk to you about those. I'm sure you'll be interested in doing some with me. I've started doing some basic advocacy, how a lawyer asks questions and that kind of thing, because even if you never plan on going to court, it will make great conversations when someone's trying to give you gossip. Did you hear so-and-so's done this? Well, really? How do you know that? Well, John told me. How does John know that? Well, he saw, an email or whatever. So it makes for interesting conversations. Paws and Fins, fantastic username. I love that. Welcome to membership as well. I'd play a little sound if my previous software had worked, which it didn't. I've got like an applause and a dong and a welcome and nothing, but it didn't work. So I'm gonna have to look that up.
I do love that picture. I just like to say I do love that picture of the kitty and the fish going, I'm not very happy about this.
Yeah, absolutely.
There's this really well. It might be one of these unlikely animal friendships and like together they fight crime. I don't know.
Yeah, where he literally fishes him out to kiss him or something. But I saw another super chat. I did yours, Optimus Prime. Thank you very much for that. I really appreciate that support, and I'm sure I think I missed one, but maybe. Oh no, I think Optimus Prime upgraded. That was it. So there's various levels. There's student, consumer, business, and then law student gets everything. So check those out. So ultimately, I think the consensus, Al, is that these interviews are a bit of a PR disaster. That's my view, my take on it, because I am certainly picking it apart because there are certain bits in there that scream to me. Now, I keep saying I'm not a body language expert. I probably am because it's what we do, Al. What do you reckon, Al? You know when a witness is telling the truth, don't you?
Well, to an extent, there is a couple of points here, though. One thing I'm always very cautious about, and the law does recognise this, and there's a thing called the bench book, which judges here get, and actually that is now available online. It used to be very, very secret. It tells judges how to try trials, and one of the things they are reminded is the most compelling, confident, trustworthy, believable witness might be wrong. And the most dishevelled, useless, hesitant, nervous witness might be right. And you've got to be a bit careful. In real life, we survive life by being good at reading other people, and spotting who we can trust, who we can't trust, who we can deal with, and who's not going to mug us. But sometimes people have suffered consequences because they have not reacted in the way that people expect them to. There's the famous, like Lindy Chamberlain, that's the Dingoes Ate My Baby case. She was convicted because people said she's not reacting like somebody who's just lost a child would react. And now we know a bit more about mental issues and that women can be on the spectrum as well. It was like, well, maybe that's because she was demonstrably innocent as it turned out, but everyone, she's clearly guilty, just look at her. So I am always cautious. However, I have to say, and this is stepping outside. This is opinion, not
not even legal guidance.
So I am no more qualified. I think lawyers are actually quite often less qualified than people to judge sort of like assessments like that because we read too deeply into it. But I mean, demeanour is admissible in court. So yes, we recognise that there are these dangers of over-judging on how people react, but you can judge demeanour, and the demeanour isn't good. But at the same time, judges are told things like, one classic example is they are told that while in a lot of Western cultures, if you're honest, you'll look somebody in the face and you'll tell them. In some cultures, it's showing appropriate deference to authority not to look somebody in the eye.
Yeah.
But that can come off across. People go, well, he's being evasive and shifty. And it's like, no, because you're counsel and you're cross-examining them, the reason they're not looking you now is they are respecting your authority. And that is something specifically that judges are told to keep an eye out for. So we do recognise that it's always a bit dangerous solely relying.
Yeah.
But you don't just make the decision on one. You test the evidence. You test it against all the other things. So it's not just what was her reaction there. It's what was she saying at the same time, and was there
the choice of. You're right, Al. The choice, and this is why I've done so many videos on it. If you haven't caught them, please check them out. They're all linked in most of the descriptions to most of the recent videos. I've painstakingly gone through the wording and the emotions, and any one of the sort of emotional reactions by itself won't mean that she's being dishonest. But when you take that together with several others, plus wording that is either couched in qualification or just contradicts something, like I did one. I was out in Birmingham Wednesday, and I squeezed a video in the middle of my day, and I talked about if I'd injured my knee, which I have. It's getting better now, but if I've injured my knee, I would naturally point towards the knee that I've injured. And as I was doing the video, I was pointing to my left knee, which is the one that I'd injured, not the right one, the right one, the left one, which is the one that. And so when she did the testimony, when she said it hit me in, and she gestured towards her left eye. The photographs show the bruise on this eye. Yeah. You wouldn't do that if you were recounting and talking about an event that really happened. If I were to pick, I'm full of scars and injuries because of martial arts, because I'm just a bit mad sometimes. I'm full of scars and injuries. So when I was 20, random story, And case in point, when I was 21, I was on a bunk bed in a hostel in Australia with a friend. I leaned over to pass him something, and I caught my elbow on the fan on the ceiling, and it took a chunk out of my elbow. And as I'm doing it, I'm doing this because it was this elbow, and I can probably find the scar and point you to it, you know. But as I'm doing it, I'm gesturing, I'm telling you the story, which is why I did this live. I hadn't pre-planned this at all. It's just a random story I've told you. As I do it, I'm showing you what happened. This is the blades obviously going around and hit my elbow. And I'm doing it to exactly the elbow that happened in the arm with the arm that I've reached out. And that's how you tell stories. It will be totally unnatural to do that the other way around. I'm frowning as I'm doing it because it's so unnatural. I wouldn't do it that way around because it's wrong. And so you tell yourself or you tell a friend any story that's ever happened, any injury, or if you fell on the left-hand side, you'll gesture to the left. I fell like that. And that's how you'll do it. And so it's these subtle things. You can't fake, you can't make up. They are natural reactions. And so that's how we become sort of, as lawyers, we filter out the nervousness and the gravitas of being in a courtroom with a judge and barristers and everything else. And then you test the evidence and you do all of that. And I've even done this before. I've said, you said that you hurt your back. Can you show us where you hurt? And they will turn around and they'll do this and they'll point to the neck. And you'll say, well, you've just pointed to your neck. Well, in your evidence, you said it was your lower back. So it's not the same thing, and you test the evidence like that. So it's very interesting. And on that case in point, the super chat that I'm going to come to kind of develops this point further. So we have, can you look at the split lip pic and see what you think about it from your martial arts experience? I can't, if I was quick enough, I'd bring up the picture, but in fact, I'll try and do that. Yeah, from my martial arts experience, split lip. Let me see if I can find a photograph. Images. Let's have a look. This one, I think, opening a new tab. Just bear with me 1 second. And then I'll try to add this to the stream. If it loads, great, because that'll be the one. While it's trying to load, in fact, it's not going to load, is it? That one there on the right hand side. This one here. Let me see if I can zoom in with my trackpad over here. That one there on the right hand side. That's a split lip. Now, from my experience as a martial artist, the splits on the outside, there's not a particular amount of swelling. And this super chat here says vertical split on the front lip, not cresting, with no damage from the teeth in the back. The teeth in the back is absolutely the right point to make, because what I'll say is this. I'll remove those now for copyright reasons. But the teeth is the big thing. We wear a gum shield for martial arts and for rugby and everything else. And I always say this, when someone says to me, I don't need to wear a gum shield, I will say to them, and forgive me, warning, this is quite blunt, but what I'll say to them, you will only be kicked in the mouth once without a gum shield, and you will never not wear a gum shield again. And then when the look of horror comes across their face, they say, yeah, I'll put my gum shield in. Because I got kicked in the... I was wearing a gum shield at the time, but only the top one. Recently I will wear the top and bottom. But teeth cause a tremendous amount of damage behind the lips here. And as a result, it swells up like a balloon. And I mean, like out here, not just a little bit, but it swells up. Al, you've done some training before by the sound of it. I don't think we've even discussed it yet, but you've done some training before?
Yeah, I'm a big sort of aficionado of all the military combatives like Krav Maga and all the Fairburn Sykes stuff. And we used to do a lot of stuff, with the police, but also with like battered wives and things like that. And I have to say, I would rather go up against a fast entry team, all sort of tooled up and with batons and shields, than somebody who is suddenly reliving the trauma of the domestic abuse and has snapped out of her shell. Because that's some really, and it's good. I mean, this is going outside the topic a bit, but weirdly, sort of self-defense training is very good for PTSD even after the event, because a lot of the time it removes the helplessness component, which is a big part of PTSD. But also, a lot of the time, you get, especially you get all like, you know, the Israeli commandos going and going, look, in that situation, I'd have got battered too because the guy snuck up on you or hit you in your sleep. There's nothing to be ashamed of about what happened. You know, I think when people realize it's all about, you know, the art of the possible, it's like, look, some things you just can't defend against. You know, it's the old, you know, if you're in a fair fight, your plan went wrong, and abusers will tend to do things to take, you know, they won't want a fair fight, and that can actually help unvictimize people. But yeah, I've got lots of, I mean, all my front teeth, as you can really tell, are caps and crowns, because that's even with a gum shield, and all the ones where my gum shield stops, it's just like, honestly, it's like pre-1930s Stonehenge back there. I've just given up having them fixed because you just get them kicked out again. So I've had a lot of head injuries over the years, which I am putting forward as an excuse. So anytime I say something that doesn't seem to make sense, or you just go, "What's he on about?" Just remember how many times I have been kicked in the head.
So there you've got it. Gonna be a doctor soon, if that is your real name. I hope you probably will be if you've you know, if you've put that there, you've put it out there. I do believe this manifestation stuff. A lot of people think it's mumbo jumbo. I believe in this manifestation stuff because I was literally watching law programs one day and said, do you know what? I'm going to be a lawyer.
Yeah. And
it took me years, but here I am.
Visualize it and it comes.
If you see it's going to happen, it's going to happen. So you've got your answer there. That's what I think of the split lip. I think, what do I think? I'd go out on a limb and say it's anything but being a violent attack, because I've seen split lips from controlled martial arts environments which are 50 or 150 times worse than that. And that was when someone went, "Oh, sorry, didn't mean to catch you," when you've just been caught in the mouth like that. Am I right? Right. So you got your answer there. So thank you for that. Thank you for your kind super chat as well. As a Brit living in New York, loving your channel. Thank you very much. Dying for the law tubers to comment on the amazing Mohammed. Okay. Yeah, absolutely. Yeah, I'm sure we will all be doing that.
I'm speaking of notes.
Yeah, I will take I like to take screenshots to remind myself to make sure I do cover things. So I will do. I will definitely look at that. Thank you for the super chat. I appreciate that, as always. And thank you to you too. Well, Johnny could just be the weakest man on earth. Showing the commentary. Well, you say that, but let me give you an imagery and then tell me what you think. Most people, I say most people, would think of a very, very young child, let's say 2 or 3 years old, as being weak. I'm not being disrespectful, but most people would think of a 2 or 3 year old as being weak. Now you imagine any 2 or 3 year old that you know of being angry and whipping you in the face, straight in the face, bam. However small and weak you think they are, how do you think your teeth would feel after that? And if you're in any doubt, just take your own fingers and just tap your own mouth a little bit, just gently. You know, don't want you to hurt yourself, but just gently, and then imagine a 2 or 3 year old slapping you in the mouth like that. Yeah. So even someone weak, as Al just said, you know, better probably than a trained response team, because I think a trained team would do lesser damage. What do you think, Al?
Well, yeah. Well, apparently the police, the Home Office training is to do stuff that doesn't cause permanent damage, but the sort of abused women training very much isn't. And it was good. I know it sounds awful because we're trying to bring people out of their shells, and You know, some of them very timid, very unconfident, and some guys just didn't like the fact there were blokes in the room with them. You know, it's like, hey, we're here and we're going to get a bit grabby, and are you comfortable with that? But once they'd come out of their shell and we'd shown them a few little techniques and things, and like I say, this doesn't, you know, make you invincible or super. It's just little things that might assist you. But all of a sudden, it's like a collective thing of, yeah, let's just go for it. And even though you wear all the padding and you wear all the groin protection and the gum shields, and in the end, we were putting on all the full head armor and things, because it was just, this is getting really serious. You know, you don't need to take too many elbows in the face before you go, you know what, I think I might just put this helmet on.
No, exactly. And just on point, this was, I mean, this has touched a lot of people with Johnny in this case, and actually pushing through. So my dear wife is in the room next door watching the live stream, and she's also on YouTube. She's over on Easy Chinese Cooking. So go and subscribe if you haven't already done so. And she has something to say, actually, from the door about Johnny. What would you like to say?
Going through the lawsuit twice, not once but twice, is a real strength. It takes a lot for people to go through that. We see grown man crying. It really crawl into you, the lawsuit. But for him to really going through that to clear his name, that takes a real strength. So do appreciate that.
Couldn't agree more. It does. It takes a real strength to go through cases like that. And go on now.
So I was just going to say, this comes back to, you know, there's been this idea about the jury going home and whether they saw social media and things. Now, it's going to sound, being in a trial, even as a jury member, where there's a lot of pressure on you because you have to, your duty is to focus and concentrate. I don't think people realize how, even as a non-party, how stressful and tiresome and fatiguing trials are. And I'll tell you, if I'd been sat in a court for 8 hours, the last thing I would want to do when I got home is hear any more about it. I would, and I suspect that's probably true for the jury. I suspect when they got in, the last thing they want to hear from their friends is, oh, how did it go today? We saw you. It's like, oh, please, can you just stick Coronation Street on, or what the American equivalent is?
Yeah,
you know,
absolutely.
I just want to relax. I don't want. I've had this for 8 hours. I don't need any more of it. I mean, I'm back there tomorrow, and I'm doing another. You know, you're doing 7 weeks of this. It's awful. I mean, and this is another reason I always advise people not to litigate if they can avoid it, because the stress of litigation, even when you're not in the courtroom, everything around it, the preparation, the disclosure, it's absolutely draining. I can think of very few people who at the end of litigation, where you know, some corporate litigation where it's not very personal, but even have gone, I'm glad that happened. Some people go, I'm glad we got the right result, and I'm relieved about that. But you sort of go, if you could rewind the clock back to say, I'd just rather it hadn't have happened in the first place and we didn't need to go to trial. And that's people who've won.
No, absolutely. Alex, interesting question. I know you've mentioned this before, Al, in what you've said before, but the Australia tape with the finger incident not admissible in court because of multiple third parties, perhaps. Most likely, because again, anything hearsay is inherently difficult, and it does. In England and Wales, this is a thing that a lot of people don't get, is that hearsay is just readily admissible here, but whether it's reliable or taken into account or not is the judge's decision. Because in civil, it's just we generally we trust the judge to say, yeah, hearsay, I don't want to consider that. Any other thoughts, Al?
Yeah, just that's because in civil trials here, the rules about evidence are a lot more relaxed, just because you've got a judge who knows what's admissible and what isn't, and what weight to put on things and what weight not, you know, how much weight to put on things, even if they are admissible. And we trust judges to get that right. In criminal trials, it's slightly different, obviously, because it's a jury. But again, we tend to it's a slightly different culture in America where it can be very objection heavy, because here we tend to sort of prefer the trial to run smoothly, and judges will give people directions at the end, and we trust juries to say, look, you heard that's actually irrelevant, put that out of your mind, put that out of your mind. The standard direction they give here for juries for social media things is, you know, they quite often they don't necessarily say don't read it, they just say try not to read it, ignore it. But what they say is, you must try this case on the evidence you've heard here. So they give the legally. This is the only evidence that counts, not anything else. But some judges will give a formula like, right, and just to emphasize this, imagine like somebody's making an important decision about you, like a promotion or something like you. Would you want them to take into account what they heard down the pub? And people go, oh, God, no. You know, and it's like, and once you explain that to them, I think they go, right, that's why nobody else's opinion other than what we're seeing matters. And I trust juries to get that right. And I certainly haven't seen any evidence to suggest juries don't take their oath very, very seriously.
Yeah, absolutely. Interesting comment here. Thank you, Nelly, for your super chat. My husband and I went through hell with his ex, wanted to react. He told me to ignore. Staying quiet took all my strength, but it was so powerful. This is actually something I will come to, which I will talk about this, because there is a strategy in a lot of difficult circumstances, a lot of difficult cases that you might be placed in.
I so agree, because it's easy to share your opinions, but it's harder to shut it and see the bigger picture and move on.
Can you hear, Al? Yeah.
Yes.
Yeah. No, that's my dear wife, obviously. And absolutely right. It is so easy to just blurt out what you think, and staying quiet takes a lot of effort, a lot of willpower, and staying quiet is really powerful. Most people will want the fight. They'll want the argument out in the open. They want you to react. Most people want you to react. They want the reaction. They want the airtime. They just want your reaction. They want your attention. And a reaction is attention, whether you do it directly or not, whether you do it publicly or not. But it's your attention. And so most people want that. And staying quiet is really powerful. So if you can manage to stay quiet, that is a really powerful mechanism to deal with things. So my very best wishes to you, Nelly, and I hope that staying quiet helps you, and you can continue to do that. I think it will help. Laura Frost has joined as a member. Welcome. That means you will get this stream in full at the end. And I am going to clip snippets of it, but you'll get the full version as a member. There's tiered members, and I always look at your comments in order when I'm looking at new videos. So thank you for joining. The join button's below if you haven't spotted it. Today, I hear you about the 2 to 3 year old hitting you and it hurts. Yes. My soon-to-be 2-year-old grandson will accidentally headbutt me, and man, it hurts. Has given me a big lip. There you go. Accidental buff in the lip, and it swells up like a balloon. Not a tiny little something. It swells up like a balloon. Anyone that's been in a fight, or anyone that's done rugby, or anyone that's done martial arts will attest to that. Or sadly, anyone that's been a victim of any kind of abuse, they will. Oh, here's a point. Your time to shine, Al. Have you talked about the ACLU charges? I do see another super chat that I might interrupt you to come to when I find it. I have to scroll up and down to find these things. Okay, it was just a thanks. So we're talking ACLU now, guys, and their claim for costs. But I'm going to also thank Coco for this super chat at the same time. Take it away, Al. What are your thoughts?
Yeah, well, we were going to chat about this. Okay, first of all, just to explain what the ACLU thing is about, right? When you sue somebody, we go through a thing called disclosure or discovering the states, where you have to disclose what evidence and documents you have. So everybody has to exchange those. Sometimes, though, you may say, well, actually, there is some evidence that I need, but it's in the control of a third party who isn't a party to the case. And for technical reasons, I don't have a beef with them, so I can't make them a party because I don't have a claim against them. But I want the evidence they have. And you can ask for it, say, could you help me? but they might say, well, no. So you can apply for something called a third-party disclosure order, and that's the same in the US and in the UK, where you go to court and you say, we think this party has some evidence that is essential to this case being tried properly, because in the absence of this evidence, it wouldn't be right. You couldn't make a decision because you've not got the full facts. And you go along and you say, we want this person, this is the evidence we want, and we want you to force them to hand it over. And that's what actually happened in the UK trial, where the Depp's team went for a third-party disclosure order against Amber Heard. And the judge said, well, no, I'm not going to make an order against her. You'll just have to deal with whatever the Sun provides you. In, however, the US case, Johnny Depp's team brought one against the ACLU to say, we think you have some evidence that is pertinent to this case. That would assist us in terms of, and it was all the background to the donations. And of course, then it transpired, they had effectively they had libel checked the op-ed. And there was all that thing that the op-ed had been done sort of in collaboration. So that was a very useful exercise. But the rule is, because the third party doesn't have a dog in the fight and isn't, it stands to gain or lose nothing from this, why should they have to pay for the cost of the disclosure exercise? So the usual rule is, if you are successful in obtaining third-party disclosure, because you're the one who wants the evidence, you pick up the tab for producing that evidence. Now, what the ACLU have done is, there's no dispute. They're saying that you're totally entitled to your photocopying fees and paying some staff to pull things through the archives. The issue now is, should you have to pay for because the ACLU got lawyers to check what was disclosable, and they objected to this disclosure, and they did a very, very sort of detailed analysis of what should go in. And the argument is, should Depp's team, or Depp really, have to pay for all that work? Because that was to benefit the ACLU. They could have just handed it all over. Now, I've read the actual, because I am so nerdy, I read all the applications in this. In fairness, the ACLU make a good point, because Depp's team said, we want you to, if you're claiming any sort of privilege, we want you to line by line do it for every single document. Because they would say, well, this class of documents we say, isn't disclosable because of X. These documents aren't disclosable because of Y. They said, no, we want you to do it for every document, and say why. And they're saying, well, that cost us $86,000 or something. So this is the issue as to whether Depp's team have to pay for all that work. And the ACLU's argument is, and I can understand people say, well, the ACLU are the villain of the piece and they're on Team Amber and therefore they should suffer the consequences. But the law just had, as far as the law is concerned, they're not a party. So should they have to pick up the tab for that? I personally think the judge is going to say, yes, Mr. Depp's team, you must pay the ACLU's cost, but I think she's probably going to knock them down a bit on the actual amount of charges, because they might say, well, actually, some of that work was unnecessary. Some of your billable hours are a bit expensive, although Depp's team actually do concede. Lawyers always concede that other lawyers' rates are really reasonable, because because we don't want to be on the receiving end of that. This is outrageous. How can somebody charge this many dollars per hour? Because of course, then the next day you're back in court going, well, we want to claim our costs and we think these are perfectly reasonable. But that's what all this is about. Now, this brings us to another thing, and hopefully this is something your viewers can use. How do you decide who to sue, whether somebody's a party or somebody's just a potential witness? And disclosure can be a part of that. You can actually do what they call pre-action disclosure. We can go to court and say, I am thinking of suing somebody, but it might be they have a fantastic defense to this. And rather than go through all the expense of a trial, I'd like you to order them to do the disclosure beforehand. Because if it comes back and I think, oh, actually, yeah, I'm on a non-runner, I'll take a view to discontinue the case, or to decide who I should properly sue. So that's actually called pre-action disclosure. There's an interesting case at the moment where somebody applied for pre-action disclosure, but after they'd issued the claim, and they go, well, you jumped, because two departments weren't talking to each other effectively. So somebody said, oh, we need to sue these. And the other people go, well, we need to find out whether we should sue them. And the court has said, perhaps not unreasonably, you can't apply for pre-action disclosure, post-action. But this all comes into it. And at some stage, maybe we should chat about, what do you do? And this is for your viewers, because Depp had to decide, did he sue the Sun? Did he sue Amber Heard? Did he sue the ACLU? What if you pay for somebody to install a new boiler and it doesn't work? And the builder says, well, I installed it properly. It's the boiler's not right. But the boiler people say, no, the boiler's fine. He just did a bad job. And you just don't know. You're not an expert. Who do you
common complaint? It really is. I mean, and sometimes I'm sorry, I'm just looking for a super chat at the same time. But I will find it eventually. But it's a common complaint that something's been purchased and installed. There's two people. I found it. I think it's this one. So I'm going to put it on screen so I don't lose it again. So forgive me for the delay for getting to you. But it's a common complaint when someone has either bought something, it's been purchased, it's been installed, and who's to blame? Is it that the thing doesn't work, or has it been installed badly, or has it not been maintained? Is it damaged by the person that runs it? Did they not run it properly? Who is the correct defendant is the appropriate question. And the way the law looks at this is very bluntly, well, sue them both if you don't know who it is, and the court case will decide who's responsible. It's just that if you lose completely, you're responsible for both parties' costs because you've wasted everybody's time and costs. And so ultimately, if you're definitely right and it's one person's fault, then the other person's been brought in because it was their fault, then they'll have to pay their costs. And so
it's a big thing as to whether, because by definition you can only succeed against one person, so the winning defendant is entitled to their costs, but it's whether you pay their costs or the losing defendant pays their costs. And that's a practical issue that crops up quite a lot. Another thing is, if you are being sued yourself, say you're a builder, you put a kitchen in and somebody sues you for negligent work, and you're saying, well, actually it's all hypothetical. Travis Perkins, not suggesting Travis Perkins would be at fault, but it's Travis Perkins applied the wrong thing.
You must be a defamation lawyer.
I know. It's like, yes, I'm using them as an example. Travis Perkins is actually a very, very fine thing, and they're an excellent source of free coffee, I have to say. But yeah, if you are being sued by somebody and you say it's not my fault, you're suing the wrong person, you can go back and say you should sue that person. But if they say no, I'm suing you, you can join the other person as a defendant.
You can join, absolutely. You can join them and lay the blame at someone else's door.
Yeah, you just go to court and say, I want you to add this party as the defendant because I'm saying it's their fault. And that happens. And that happens. So
I had a very interesting case. There was fraud involved, and fraud is one of these where it cuts through what we call the corporate veil. So you have a company limited by shares, limited liability for the purposes that the individuals behind the company can't be personally bankrupted by the actions of the company. Therefore, it's a limited liability. However, fraud will cut through that because the law says you can't set up a company for fraudulent activity and then protect the people behind doing the fraud. That just doesn't make sense. So you can cut through. So we had an interesting case, and I will come to the super chat question in just a minute. Great. Well, I'm sure Al's got an answer lined up, but it was an interesting case where we were suing the company, and the people responding said, this company has got no knowledge of this customer. I mean, like, nonsense. We've got documentation from you. It's clearly from you. And they said, and one of the directors said, no, it's this guy, pointing at one of the previous directors. So we said, well, do you know what? Because of what you've said, we don't know who it is. We applied to the court to apply it to add everybody to the claim. Everyone can come to the party. Long story short, we got the judgment against everybody, the company, the directors, everything, because the whole thing was a bit of a sham. So said the judge. And so we got this huge judgment against them all. So do you know the etymology, Al? Cuddling badgers? It
was a reference to something I've just posted in the chat, a link to the relevant Guardian article. No, because what happens the day after the verdict, Johnny Depp was seen publicly cuddling a badger at Badger Sanctuary, and I have to say, even I said, "Oh, come on, mate, dial it back a bit." I mean, I can understand why you're doing the PR rounds, and I love badgers, and it's great. Under any other circumstances, I would have said, "Oh, that's sweet, he's cuddling a badger," but it just seemed a little bit, I don't want to say contrived, but it was almost like where politicians like, "Oh," it was the most sort of publicity-friendly thing you could do. Oh, look, I'm friends with badgers. I'm cuddling a small child. I'm just doing some charity work. I've posted in the link, but I do think maybe we should try and make it an idiom. So yeah, go cuddle some badgers. But it was a reference to the fact that the day after the trial, Johnny Depp was very publicly cuddling some badgers.
Yeah, no, quite right. And Hev, thank you for the super chat. My son went through this. He won, but now is a changed man. Shut himself from family. Want to go for defamation, but the cost, awful. Yeah, sadly, you're right. Before I became a lawyer, I had to go see lawyers, and we were talking about a potential case. And the lawyers said, "How much do you want to be right?" And me, as the then lay person, thought, "What do you mean? How much do I want to be right? Of course I want to be right. I want with every fiber of my being to be right. This is, we're right, they're wrong, etc., etc. Let's go. Let's do this. Let's go to court, fight." And he said, "Well, it's going to cost a lot of money and blah blah blah." And so the very sad reality is, yes, it can be, unless you do it all yourself. But even then, it's not the monetary cost, but the emotional and the time cost of doing it yourself is just horrendous. So I feel for you. And sometimes the best you can hope for is to move on and put it behind you. It's not easy, but that's sometimes the best. But no, I hear you. I'm sure Al will agree that.
Yeah, I totally empathize. I think there are two things. First of all, there's the frustration that, there might not be a legal remedy, or it takes a lot, or it's expensive, or it takes a very long time, or it's very draining. But then there's the fact that even if you go down that route, if you issue a claim today, you will be lucky to have a trial within the next 12 months. So you've got all that hanging over, and that's even for a simple case, but you've got all that.
However small they are, indeed. Yeah. However small they are.
Yeah, and like, litigation is traumatic because you will have to stand there or sit there, depending on how the court is set up, and you will have to face somebody putting their case to you, and that could be horrible. That could be really, you did this and you did that, and isn't it true that you did that? And like I was saying, one of the tricks that lawyers will quite often use, this was very cleverly done in the Depp cases with the pledge donation thing, is they'll put a question to you where the answer is personally embarrassing. It's not particularly relevant to the case. And we do have this rule that we can't ask a question just to embarrass or upset a witness. But if it's a question that is permissible because it is slightly relevant, we can ask it in a way that you will squirm and you will hate it, because if we can get that, look how evasive this person is being, look how aggressive this person is being. And that does happen. So, but being cross-examined is awful. I've had to be a witness a couple of times on relative minor things, and even it was interesting. I liked it because it was the one time I just didn't care what the result of the trial was, because it's like I'm just a witness, and it was so nice not to be under the pressure to care about the result. But even that was a massive inconvenience. There's lots of sitting around, and there's lots of and just being questioned and having your integrity put forward. I mean, it was a very interesting case. It was actually a case where I'd actually had to punch an ex-client. Sorry, but I'll tell you about that sometime. But it was, I didn't care. I genuinely just didn't care, because it was like no. But even that, I can imagine that had I been in this unfamiliar environment, and it's the same thing. If lawyers go to hospitals where it's outside our sort of zone of competence, as they say. If I go to hospital, I take a friend who's a medic with me, and I just get her to explain what everything is and what all the beeps are and what's going on in that room. Because it's like, I have no idea what's going on here. I don't understand the language. I don't understand who everybody is. I don't know what's happening. I'm sat here, and somebody has to hold my hand and take me through it. So I really appreciate that when people step into our arena, how just uncomfortable that is and how disorientating. And it's not like you get a lot of lead into it. You just dumped in there. So I mean, court proceedings are absolutely horrible. And that's one thing I think about this Depp and Heard thing. Whatever, it's been really useful for illustrating legal points and talking about advocacy and talking about all the issues in the case. But at the end of the day, wherever you think the truth lies in this, a lot of people, two people especially, have had all their vulnerabilities and most darkest secrets forensically dissected in public, and that is not a pleasant experience for anybody.
No, not at all. And you're right in something you said earlier about, very often the advice is to not to take the case, or sometimes not even to defend the case, because if someone's making a claim and it's a certain amount of money, and it might be quicker and easier and cheaper to just say, do you know what, we call it a Calderbank offer, which is, we think you're wrong, but here's a few £100 to go away, or a few £1,000, whatever the case might be. So it's not like that. We have certain offers without, depends how much we're going to want to go into detail here, but we have certain types of offers that have cost complications and consequences. So if you make an offer that they should accept because they won't do better at trial, then they'll be punished in costs orders at the end of it if they don't better the deal. But that's the simple version. Beneath that, we have a Calderbank offer, which is, we think you're wrong, but we really can't be bothered with your lawsuit right now. Here's a few £100, go away. So if they go to court and say, haha, they offered us £300, so we're right, you can say, no, we offered them £300 to go away. We think they're entirely wrong, but we just said, here's some money, go away, because by the time you pick up the phone and speak to your lawyer, it's cost you that much anyway.
Yeah.
So sometimes it is easier. I've advised somebody for free to not instruct me for money because it's not in their interests. Remember, we're under a duty at all times, if we take on instructions, to act in that person's interests, and that kicks in even before we've taken any money. So if we know that they will not recover the money, so here's the example. I'll tell you exactly what it was, without the details, without the personality of it. They had a claim for about £350, so virtually nothing in our world of coming to lawyers, and they lost. They wanted to appeal. They wanted advice on the appeal, and they wanted to run the appeal, permission to appeal, and so on and so on and so on. And it would cost as much as that to even get advice on whether it's worth appealing, even if it's out of principle. So I picked up the phone and essentially said, my advice is, even if you win, you're going to be financially worse off than you are now. My advice is to just leave it and pay it, because unless your instructions are explicitly clear that you only want to clear your name for anyone that is aware of the judgment, and the money doesn't matter. If those are your instructions, then I'll advise you, but it will cost you more than you're ever going to win, even if you win, which you probably won't. And so it's such a weird position to be in, that you're under that obligation to advise. But we are. That's the ethics of the bar.
Yeah. I advise people not to litigate all the time, and I had a con earlier where I just said it's not worth your time instructing me. Although after the con, we suddenly went, actually probably is. But offers are really bizarre. I mean, I've got to do, actually, I'll ask you about, I was going to seek your advice on this, Dan. I've got to do what's called a Part 36 offer, where there's a claim, there's a counterclaim, and both of them are for non-monetary relief. And it's just like, how do you put that together? Because, how do you beat that? I mean, it's very complicated.
No, exactly, because for those that are not familiar, a Part 36 is it's Part 36 of our civil procedure rules. So it's an offer to settle the claim and the entirety of the claim. And if you don't beat it at trial, there are consequences. So the court will generally not punish a defendant for making a bad offer, because it encourages offers by the defendant. But it will certainly punish a claimant for not accepting it, because why continue with the claim if you should have accepted the offer if you don't better it at trial? But where you've got both of them and they're non-monetary, how do you weigh that up? Because
we want a declaration, they want an injunction. How do you beat that? I mean, what's the definition of beat? Because if it's exactly, because if it's an offer, if you settle, there's no order. And I had to explain this to a client very recently.
that a court judgment can come in the form of a non-monetary order, which is an injunction. And so it's not monetary. And so my client thought that it's not what we call a CCJ, a county court judgment, but it is, because it's an injunction. So there's a CCJ, but their whole remit is they wanted to avoid the CCJ. I am for anyone watching, I am desperately trying to look for your super chats as I talk. I have one sort of loyal moderator in the chat right now. You can probably see tirelessly working away, trying to remind me of the super chats. I do see them, and I'm desperately trying to find them as I talk. So I'm multitasking. We do that as barristers.
Yeah. So one thing that people might find interesting, actually, because it's a topic for another day, because it is about settling cases. And don't forget, 97% of issued claims ultimately settle. They don't make it to trial. But there are all sorts of ways of settling and what we call consent orders. There's also something we call a Tomlin order. And the interesting thing about that is a consent order the order can only do something that the judge would be allowed to do anyway. Even if you hadn't settled, it can only sort of record, I will give you money, I will give you an injunction. But you can do something called a Tomlin order, which is, we can also agree, in order to settle, that we can agree loads of other things that a court wouldn't be empowered to order either side to do. But you can actually stick that on the back of the court order. And again, that's just to flag this up, but that's a very, very common way of resolving disputes. Because I've had this where, somebody's suing somebody about one thing and another thing, and we've settled that, but we've got loads of other rows going on between us about all sorts of ridiculous issues that aren't even ones that a court might be able to deal with. But we stuck all those in the Tomlin order as well, just to stop the parties having any more reason to be having a go at each other. So, but that's something, maybe a conversation for another day. But yeah, settlement is, but you've got to judge it right, because mediators always say this thing, because Dan, you're a mediator, so you know it's better than I. But mediators always say a good result is one where everybody walks away equally peed off. Yeah, absolutely, exactly. A successful mediation is nobody's happy. Yeah. If one person's happy, it's not a fair deal. Yeah, and that's such an odd way of looking at it. But you've got to get your head around it. For anyone that's put up a super chat, I apologize. The chat is crazy with thousands of comments. I did not ever deliberately ignore you. So if I missed it, make sure you tell the moderators or DM me, and I will give it attention in another video, and you'll see it. I am desperately looking for any that I think I've missed, but I would never intentionally ignore them. But because there's so many chats, there's been over consistently 4,000 or 5,000 people. So I will do my best to get to them all as we scroll through and chat. And I'll do them as they come in, hopefully. But Precious says, love your podcast, but I disagree. That's fine. Everyone can disagree. I hate to see anyone destitute too, but she's the type of person that will harass him for the rest of his days. I say take the money and donate it. Well, actually, in that case, I'll turn you around and say that I agree with you, because if I were him, I would take the money, and I would, if I didn't need it, I would donate it, or regardless whether he needs it or not. The jury said he deserves it, so he deserves it. But whether he donates it is clearly his choice. So I think when we say, he's done with it, he's moving on, doesn't need the money, I think it's kind of his choice, really. If he does that, if he chooses to do that, that's his choice. Whether we advise somebody, our strict legal advice would always be pursue the money by every means possible. That's our strict legal advice always, unless their instructions are that they want to be done with it and just no more court, no more hearings, no more applications, no more motions, nothing more, move on. If that's the instruction, then it's like, well, yeah, you don't need to pursue it. So thank you, Precious, for your super chat. I hear your thoughts, and I'm with you on that. So my thoughts with you. Mo as well, I'm coming to yours to make sure we don't miss yours. Handwriting extremely similar to the therapist. Yeah, I saw the post with the H, and
it will be very interesting to say the least. I don't know if you saw that, Al, but there were close-ups of the handwriting with the swirl in the H several times over.
I've seen just little bits on this. This is only just cropped up very recently about this. But of course, it's one of these things where proving the authenticity of documents is all part of litigation. The general rule is if you agree that a document can go in the trial bundle, you are agreeing it's authentic. So if you do want to challenge, so, you know, and this catches a few people out, actually, especially if they're acting on themselves, they'll say, I want to say that, you know, this letter, you didn't write it. And the judge will say, well, I'm sorry, you've let it go in the bundle. So you've accepted he did. So if you want to object, if you want to say, I do not accept this is an authentic document, then you have to object. And then there are ways of going off and appointing experts to check and all that sort of. But this also comes back to that thing I was saying the other day about indisclosure discovery. Never accept photocopies. Always go see the physical document, just so you can spot things like this and, you know, what colour ink they're using and how hard they press and all this sort of thing. But yeah, I mean, that is so. Assuming this goes anywhere with these therapy notes, you know, that would be an issue for the parties as to whether they accept that they're even genuine.
Yeah. So I'm just putting a banner up here. So hang on. If there are any missed super chats, let the mods know or let me know in the DMs, and we will address those at some point. I know I think there's one or two that have slipped through because my chat thing here scrolls through. This is why I want better software. If anyone knows better software than StreamYard, StreamYard is very good, broadly speaking, but it's not good enough for the number of people that we have on here. We tried eCams, but didn't work as well as I wanted it to. Thank you, Gonzo. I appreciate the comments. I don't know how you are for time, Albert. Maybe another 10 minutes.
Yeah, I'm fine. I am absolutely fine. I got another con later on about a nice little IP issue, but you know, when that's all settled, we can have a chat about that because we're running a very interesting argument in that one as to it's all about appropriation art and what you have to do if you're basing your art on somebody else's artwork to create a fresh copyright.
Yeah, and so that's an interesting point. I mean, it's totally off topic, but yeah, well, I think we'll do a stream about that. That might be quite interesting. I think I got all but one or two of the super chats, so do forgive me if I didn't see it or manage to get it on screen. It definitely wasn't a deliberate slip up. Optimus Prime, thank you for enjoying the time here. This is one, I don't know whether this is one that I...
Helena's was the fantastic question about cuddling a badger.
Yes.
I think we should try to make that into an idiom. So it's, hey, go cuddle a badger. I don't know if it's a good... Yeah.
Absolutely. I'm desperately... I've got two chats running. One's the live one and one's the StreamYard one. I'm going to spend the weekend researching better live stream software so I can make sure that nothing gets missed, which is what I thought I did with eCams. But when we started it up, even despite my testing, when we started it up, I got echoes, which was not great.
I can jinx any software, trust me. But this is the annoying thing is because during the COVID, we started doing all the trials by like MS Teams and things like that. It was an absolute nightmare because I had one case where the judge's picture had frozen. And I just sort of said, I said, oh, sorry, you know, Your Honour, but your picture's frozen. I said, it's ironic because I always tell the bar students about this. And I've always been telling them about judicial feedback is really useful and watch what the judge is doing. So I said, unfortunately, at the moment, I have no idea whether my points are landing really well or I'm just dying on my arse. And the judge just said, well, you just carry on, Mr. Roberts, and I'll tell you at the end.
Fantastic. Oh wow, 3:24 a.m. I feel for you. So you must be a special kind of interested in law to be listening to this at 3:24 a.m. in the morning. More dedicated than we are. And welcome to Margaret to our team channel membership. Always happy to have you. That means you will get access to all of the back catalogue of live streams, hours and hours of live streams you can go back and listen to. Lots of them UK based, not all of them, but some of them fairly generic. But lots of them, well, all certainly on law and my general insight to life and living it up, as they say. So UKR 69 says, give me a shout out and I'll pledge £100. Are you going to pledge it or donate it? That's the real question here. Claire, thank you for the kind comments. I appreciate that. I do see and read as many of these comments as I possibly can. You understand, we get thousands of them and I read as many of them as I possibly can. Al and I are very grateful.
Very.
From our recent member, Optimus Prime as well. Great live, great collab. Thank you very much. We appreciate the comments. So last few questions and comments as we draw to a close then perhaps. And so we can all get to the rest of our day. I don't know what time it is where you are, but it's 6:30 in the evening over here. Wow, 3:20 a.m. there. We really are. We're going international, worldwide, and all times over the planet here. 11:27 a.m.
Outreach. What's interesting though is it's very interesting comparing the sort of US. You know, it's lovely to have people from all around the world because I like hearing about other, you know, comparative jurisprudence, to give it the technical name. And that was one thing we all did a lot during the lockdown. Lots of lawyers and judges were online chatting because there was nothing else. You know, we had lots of conferences about how to be online. It's always interesting to find out how other people and other jurisdictions work. And you know, the one thing to remember is, although technically speaking, all jurisdictions are independent and decisions of other courts shouldn't have any relevance, we quite often say that decisions of other competent courts in other jurisdictions have persuasive authority. And yes, a lot of the time you'll go to a court and say, look, an American court considered this, their law's pretty similar. Do we really need to reinvent the wheel here, or should we just adopt the principles they did? This crops up all, you know, the animal rights stuff. We're always doing this with our animal personhood thing, which we lost. That. Poor old Happy the Elephant, we lost that. But on a 7-2 in the New York Supreme Court, and the two dissenting judgments are really interesting because, and there's always this idea that the dissenting judgments eventually become the settled law. So that's quite reassuring. But yeah, comparing and listening to what other people have to say about their own country's law and how things would be done there is particularly fascinating. But yeah, the reason we do monitor other jurisdictions' legal proceedings isn't just out of curiosity, although that obviously helps.
Yes, because
we can use it. Yeah.
And no, we're neither twins nor brothers even, but maybe great minds look alike. Who knows? Hell's Gate, if that is your real name. Thank you for your super chat. Listening to you two mentioning Tomlin orders and offers reminds of a LLB with the OU thankfully retired and concentrating on gaming. Well, enjoy the games, but absolutely, yeah, I think once studied, never forgotten is probably a fair way of putting it, isn't it?
Yeah.
Yeah. So Heidi, thank you for your suggestion. So I used Restream before, and it didn't give me much better quality than StreamYard. And we tried with Ecamm to begin with today, and it failed because it gave me echoes despite the echo cancellation being on. And then when I turned it off and turned it back on again, it muted me and no one could hear me. And then it said, we've terminated the live stream because of audio issues. I was like, thanks very much. You know, there's like 400 or 500 people just cut off because of some software issue. So not a great start, Ecamm, but Riverside FM, I haven't tried yet. I will take a note of that. So thank you for that. I'll take a screenshot as I always do. And hopefully there's a gap in the market here. Surely there is a gap in the market for I'm not slamming on Restream and StreamYard and whatever, but there's got to be a gap in the market for something that is absolutely brilliant for exactly this. I would pay for it because I want something that works well. I don't mind paying for things if it works well. Matt, yeah, I've looked at OBS as well, and much like Ecamm, it's a lot of bells and whistles. I just want something to work. I don't need lots and lots and lots of options. I just need a good few selection of options that works well, but most importantly, gives you watching good quality audio and video. That's the main thing. And second only to that is to be able to showcase your super chats, which you kindly support my channel with here, because it's you guys really that we do this for and that supports this channel. And that's the priority. That's what this software really needs to support. So someone's got to get on it. I'm far too busy to set up a team to develop this software, but someone's got to do it. Christopher says, get an A10 mini with your computer running Chrome plugin to manage chat. I'm not entirely sure I even know what you mean, but I'm going to screenshot it and look into it. Chris, if you want to DM me, I'm not precious about my email address, but my email address is in the chat box right now. If you want to hit me up with some suggestions, they would be very, very gratefully received, because I really want to set this up properly moving forward, because at the moment it's just what works and move forward with it. You know, imperfect action as opposed to perfect inaction. I could sit here for weeks trying to figure it out and never do anything, and that's not me. I get on with it. Loving you back in the USA from here in the UK. Thank you, Karen, so much for your support. I really appreciate that. We both appreciate that, honestly. We both. Al, would you describe yourself as a British or an English barrister generally, if you were describing it overseas?
Well, that's interesting. I always do E and W, which most people probably get confused about. But I think it is important to distinguish between all the, I'm a British person, but to distinguish the fact that England and Wales have a very different legal system to Scotland, because in Scotland they have the faculty of advocates. So they're advocates in Scotland, not barristers. And similarly over in sort of different things in Northern Ireland and Ireland generally. So yeah, I think it's important to distinguish just on technical grounds that I am an English barrister. So I'm not suggesting that I can practice anywhere else. Pre-Brexit, rather bizarrely, I was allowed to practice in 28 countries, even though 27 of them I didn't have a clue about. But I did actually used to practice. I've done cases in Ireland because it's a different legal system, but it's just about manageable. I like the Irish system because it's not as front-loaded as ours. It's literally everyone just turns up on the day and has the trial. And when I would say, well, our system, we exchange this, we do disclosure, they're going, yeah, but everybody will just tailor their evidence. And it's like, just throw everybody in there and say, right, he says this is what happened. What do you say happened? And just, spontaneity.
Yeah. Well, welcome to Irma to channel membership. I really appreciate that. And you can catch up on all of the previous live streams. You can binge watch hours and hours of content in the back catalog. So I really appreciate that. And Sophia, do we deal in medical cases? Well, here's the thing. I don't think Al is. I'm certainly not a medical law specialist, but we can talk negligence until you're all bored of it. And broadly speaking, it's all about duty of care and negligence. So we could talk to death any individual hypothetical situation and tell you what we think. And whilst we wouldn't hold ourselves out as specialists, we'd probably be right. Certainly between us, I think we'd be right, wouldn't we, Al?
Well, we can talk in general principles. I do sort of a lot of vet negligence cases. Well, I say not a lot. I do vet negligence cases. But to be perfectly frank, most of those cases rely very much on the expert evidence, and it's just how to interpret that and how to present it and how to ask the right questions and things. But yeah, there are specialist medical legal people out there, and they, I think there is this thing where, to be honest, lawyering is. It's like selling things. If you can, if you can sell shoes, you can sell eggs. A lot of the time, you don't need necessarily a specialism in the underlying subject matter, because fundamentally, our job is presenting cases, and quite often other people put those cases together for us. I've done cases where I haven't had a clue about the actual subject matter, but I've known how to present the case in some like bizarre technical things. So I'm going, I literally don't even know what that word means, but I'm going to, if you tell me that, I can see from the expert's report what we're arguing. But yeah, I mean, there are what you tend to find is solicitors tend to specialise more in areas than barristers often do, because solicitors are the point of contact, whereas barristers, there are barristers who specialise in areas, but I think a lot of that is just what we find interesting, because it's not as important to us to be specialists, because our specialism is presenting cases in court.
Mm-hmm. And that's a very interesting point to make, because our specialism very much is presenting the evidence, presenting the case, fighting for a party, and so on, finding inconsistencies and challenging evidence. And you can do that with near enough anything. So not being a medical specialist, if someone were to talk about an injury at a certain time, naturally the first thing you look at is, did you report it to medical experts? What did they say? Did you take photographs, and so on and so on and so on? And sure enough, before long, you're testing all the evidence. So there it is. We are beyond 6:30. We've been on, I don't know how long we've been on now, but almost 2.5 hours, believe it or not, out. But apologies to anyone that joined us at the beginning and had problems with the audio, and apologies to anybody that we had a missed super chat. I did not deliberately ignore you. I would never deliberately ignore them. But it's been our pleasure, and we thank you all for your time and your company. I think, unless there's anyone else got any very quick questions towards the end, or Al, if there's anything else you want to say.
No, other than to say thank you, first of all, to Dan for giving me the opportunity to ramble on about things, but also to everybody who watches these things and comments. I mean, I'm very grateful that people just watch, but it's really interesting to hear what people are interested in. Because like I say, if I have a mission here, and it's the same as Dan's, it's to demystify the law. That's all we're trying to do. So it helps us to know what you want to know about.
In response to this, with the part 3 interview, as soon as I can, I think it's coming out sort of middle of the night for us. So as soon as reasonably practicable.
Oh, God, now, there's a phrase I've had so many rows about. A little tip for people: if you, generally speaking, in contracts, it doesn't matter what time limits you set on things, unless you actually specify, quotes, time is of the essence. That's all. That's just guidance, really. And the phrase, as soon as it's reasonably practicable, I've had so many rows about what that means. Because what's reasonable, and B, what's practicable. It's hard to argue about what's reasonable, but then you suddenly get onto what's practicable. So there's a phrase that every lawyer is suddenly going.
Yeah, absolutely. So with that, it's been such fun. Alan and I are so grateful to you all for your patience, your time, your commitment, your super chats, your questions. It's been great fun. We will be back. We will be back. Someone says no sound. Hopefully you can all see it.
The person looking for the medical negligence. So I need to somebody does rotate.
Yeah. So thank you to you all, and I wish you a good evening. Have a pleasant day.
Take care.